Good morning, everyone. Welcome to the Panel A meeting of the Medical Board of California. I'm your chair, Lori Rose Lubiano. Welcome. Our first item of business today is the call to order.
Dr. Bollat,
Here.
Dr. Hopkins,
Here.
Mr. Lee, Ms. Lubiano,
Here.
Dr. Tsai,
Here.
Mr. Watkins. We have a quorum.
Thank you. Item number 2 for today is the election of panel chair and vice chair. Do we have any nominations?
Are you up for re-election or renomination?
I'm always happy to serve, Dr.
Oh, okay, then I nominate Ms. Lubiano.
Second, Dr. Hawkins.
Thank you. Any for vice chair?
I again nominate Dr. Hawkins for vice chair.
I accept.
I second that. Great. Shall we move forward with a vote?
Okay, all in favor for Ms. Lubiano as chair?
Aye.
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 Ayes have it. And all in favor for Dr. Hopkins as vice chair?
Aye.
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 Ayes have it. Thank you.
Great. Thank you for your confidence. Always, like, as I said, happy to serve.
Excuse me, this is your court reporter.
Yes.
And I have no idea who is speaking. I can't see names.
Okay.
So maybe if someone could state their name before they speak. I just have no way to identify you.
Got it.
Thank you.
Should we just record it as unanimous? No objections. This way it's easier.
Yeah.
Oh,
Oh,
okay.
okay. Okay. Ms. Johnson, did you hear that?
I did. Thank you.
Oh, okay.
I don't know who said it, but I got it.
Okay. Thank you. Okay, item number 3 is our first oral argument of the day. This is for Dr. Amorn. With us is our administrative law judge online, and so I will turn it over.
All right, we are on the record before the Medical Board of California, Department of Consumer Affairs, State of California. We're here in the matter of the petition for early termination of probation filed by Alan Michael Amorn, MD, Physicians and Surgeons Certificate number A94230, Medical Board of California case number 800-222-088-883. And the OAH case number is 2023-110-092. Today is November 29th, 2023. It's approximately 8:51 a.m. This is the date and time set for oral argument and the notice of hearing for oral argument. We're conducting the oral argument in person and by WebEx video conference. My name is Wim van Rooyen. I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over the oral argument today. We have previously taken a roll call of the board members, and we do have a quorum present for purposes of conducting the oral argument. May I please have the appearances of counsel, starting with the Attorney General, please.
Greg Chambers with the Attorney General's office.
Good morning to you, Mr. Chambers, and then on behalf of the petitioner.
This is Adam Sloat representing petitioner Dr. Alan Amorn.
Good morning to you as well, Mr. Sloat. Thank you so much. In this case, the board issued an order of non-adoption of a proposed decision by an administrative law judge in this matter, and then set this matter for oral argument before the board's panel A, specifically as to whether the level of discipline ordered would be sufficient to protect the public interest. As was set forth in the notice of oral argument, the following process and time limitations will apply. First, the petitioner will have 15 minutes to present an opening argument. After that, the Deputy Attorney General will have 15 minutes as well for its opening argument. And after that, 5 minutes again for the respondent for a closing argument, and then for the Deputy Attorney General, 5 minutes as well. These time limits will be strictly enforced. I will try my best to give you a warning at about the 1 minute mark, but again, counsel, you are responsible for keeping track of the time yourself. When I try to give you a warning, it's purely as a courtesy. The argument shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that will elicit any new evidence. Either I or any panel member may ask a party to support the party's oral argument on a matter with a specific citation to the record. At the end of the oral argument by counsel, I will offer the respondent physician an opportunity to address the panel if he chooses to do so. Then I will place him under oath. There is a court reporter that's present to record the proceedings for purposes of creating a record. After the oral argument, the board will go into closed session to deliberate, and the parties will not receive a decision today, but will be receiving it in the mail at some point in the future. Again, I'm just going to remind everyone to remember that all arguments must be based on the existing record and no new evidence will be heard. As a reminder, the board has already had the benefit of reading your briefs if you submitted any, but you're certainly welcome to emphasize any portions during the oral argument you deem appropriate. With that said, I will turn it over first to Respondents Counsel for your 15 minutes of argument, and your time starts now.
Thank you, Your Honor. Dr. Alan Amorn is a board-certified cardiologist with a subspecialty in electrophysiology. He practices at the VA Medical Center in Cincinnati, Ohio. The chief of cardiology at the Cincinnati VA is Dr. Robin Vanderveer Pletch. She's also a Navy veteran. This is what Dr. Vanderveer Pletch said about Dr. Amorn when she testified under oath. He is an excellent physician. He is very easy to work with. His knowledge is great. Already, you know, I have had my trainees coming up and saying what a great hire he was, what a great teacher he is. I have no concerns about his practice. I would send a family member or myself to him any day. This case does not involve negligence or unprofessional conduct in the care of any patient. The reason we are here is because of out-of-state discipline by the Ohio Medical Board. 5 years ago, Dr. Amorn had a nervous breakdown in Ohio while he was at work. In 2018, Dr. Amorn saw a psychiatrist for depression, and he was prescribed an antidepressant. The medication made him feel even worse, so he stopped taking it. The sudden withdrawal triggered his mental breakdown. Dr. Amorn's current psychiatrist, Dr. Paul Keck, explained what happened in testimony under oath. The events that you heard about were in part related to a rapid increase in the dose of a drug called Prozac, and then abrupt discontinuation of that dose. And that rapid shift in that dosage, both going up and downward, I think, and so did independent consultants, triggered a very bad nervous breakdown. He had a mixed symptoms of mania and depression, required hospital admission. Now, the Attorney General's written argument described what happened, and to be fair, I'm just going to use the Attorney General's description of what happened. On December 27, 2018, while at work, petitioner contacted his wife by text message stating that he intended to kill himself and that she should leave their house and take their children with her because he would kill her and the children if she interfered with his plan. That's from the Attorney General's written argument. Fortunately, Dr. Amorn received excellent psychiatric treatment and reunited with his family in 2019. Now, the Ohio Medical Board placed Dr. Amorn on probation in 2019, and the Ohio Board's license history describes Dr. Amorn's history, his license history, discipline history, using the language of impairment rather than on professional conduct. This is analogous to California cases related to impairment under Business and Professions Code Section 820. The Ohio license history states, based on the doctor's admission that in December 2018 he was hospitalized for depression, but has since successfully completed intensive outpatient treatment, and on the doctor's admission that he pled guilty to 2 amended charges of disorderly conduct that were related to the December 2018 hospitalization. Now, Section 820 addressed the protection of the public from impaired physicians during impairment. It is not about punishment after rehabilitation. And that is why Business and Professions Code Section 2307, Subdivision A3 allows a petition for reinstatement of a revoked license after only 1 year when the revocation was for mental illness. Now, this case was not brought as an 820 case. This case was brought as an out-of-state discipline case. But the question is the same. The question is, has Dr. Amorn's mental health improved to the point where his probation should be terminated? To answer this question, I ask you to consider the timeline of events. So, December 27th, 2018 is the date of Dr. Amorn's breakdown. July 20th, 2019, the Ohio Board recognized Dr. Amorn's successful completion of intensive outpatient treatment and allowed him to practice subject to probation. July 11th, 2020, July 11th, 2020, the Ohio Board terminated probation based on Dr. Amorn's successful treatment. September 30th, 2020, the Louisiana State Board of Medical Examiners, with full history of Dr. Amorn's discipline and mental history, issued him an unrestricted medical license. In December of 2020, Dr. Amorn joined the faculty at LSU Shreveport as an assistant professor and staff physician. In December 2021, LSU appointed Dr. Amorn as director of cardiac electrophysiology at its Monroe campus hospital. In May 2022, Dr. Keck, the psychiatrist, discontinued Dr. Amorn's antidepressant. Dr. Keck testified, quote, "He has been off any mood activating or stabilizing or whatever or antidepressant medicine since May of 2022, and he has had no problems whatsoever off the medicines." On August 25th, 2022, the Indiana Medical Board issued Dr. Amorn an unrestricted license. In February 2023, Dr. Amorn joined the Cincinnati VA as an electrophysiologist, and he serves as the director of the fellowship program in conjunction with the University of Cincinnati. On August 18th, 2023, an administrative law judge issued a proposed decision which concludes that, quote, "Petitioner has established that further monitoring by the board is not required to protect the public." On March 22nd, 2024, in a few months, Dr. Amorn's probation would terminate if he had been practicing medicine in California. Dr. Amorn has not practiced medicine in California since 2014. The only reason that he petitioned for early termination of probation is to avoid revocation of his license due to his lack of practice in California, because you can't complete probation in California if you're not practicing in California. Now, the license revocation that would occur if probation isn't terminated would trigger collateral consequences. And the collateral consequences that we are particularly concerned with are those by the Center for Medicare Services, CMS, and the Office of Inspector General of the Department of Health and Human Services, which excludes physicians from federal health programs. And the Veterans Administration is a federal health program. What we have come here today is to ask you to adopt the proposed decision with an effective date of March 22nd, 2024, so that Dr. Amorn can complete the full term of California probation without license revocation for failure to practice in California. Thank you.
Thank you very much, Mr. Sloat. All right, Mr. Chambers, now is your opportunity. You have 15 minutes for your opening argument starting now.
Thank you, Your Honor, and to the members of the panel. This is not going to take 15 minutes. This is very short. Mr. Sloat and I agree on the facts. The facts are very straightforward. You've seen them all. We don't have any dispute with the facts. There's one issue, and that's simply whether the terms of the settlement were complied with, the terms of probation were complied with. And that's the conundrum here that was presented at the end of that argument. On one hand, we have a licensee who has worked in Michigan throughout this time period and would like to have that work considered part of the probation. But the conundrum is he can't really toll, well, he can toll the probation, but not if we're going to look at the terms and conditions of the probation for out-of-state practice. And so the burden still remains on the petitioner to show that he's complied with out-of-state practice. Now, you can look at a very restrictive view of this and say he has not and overrule the proposed decision, or you can take a very lenient interpretation of that and say that, well, maybe what he's done in Michigan is sufficient. But the terms of conditions of the probation are pretty straightforward and within the four corners of that agreement. And they require practice within California within a 2-year period, and that hasn't occurred. And that's the whole issue here. So we leave it at that, and we turn it over to yourselves for other questions or for counsel for rebuttal.
Thank you very much, Mr. Chambers. I do want to give you an opportunity, Mr. Sloat, if you wanted to offer any reply argument. You do have 5 minutes for that, so that starts now.
Thank you, Your Honor. The only thing I'd like to say on that is that the disciplinary guidelines refer to the discipline as a guide for the administrative law judge and the board in issuing a decision. And that happened when Dr. Amorn was placed on probation about 33 months ago or so, 32 months ago. And after that, the disciplinary guidelines are not the issue because the Business and Professions Code specifically provides for early termination of probation. So when we're getting to the issue of termination, we're dealing with the Business and Professions Code, which trumps the disciplinary guidelines, which provide for certain elements of probation. But now the legislature has stated through its Business and Professions Code that the board can terminate probation early, which of course would mean that it didn't comply with the full disciplinary guidelines and probation would be terminated early. And the judge, the administrative law judge, made that determination that under the Business and Professions Code, that early termination of probation is warranted in this case, and that she, as part of the decision, considered protection of the public and determined that continued probation is not necessary for protection of the public. So that's all I have. Thank you.
Thank you very much, Mr. Sloat. Mr. Chambers, did you wish to offer any reply argument? If so, I can give you 5 minutes to do that.
Thank you, Your Honor. Any reply is really going to be quite redundant at this juncture. We know what the issue is. We know what the facts are. The question is whether this panel believes enough has been done with regard to the out-of-state practice to comply with the requirements of the agreement, and maybe questions of the licensee would afford the panel the opportunity to make decisions, informed decisions on their own. Thank you.
Thank you, Mr. Chambers. All right, Mr. Sloat, I want to give you an opportunity. Does your client wish to take the stand and address the panel directly?
Your Honor, what I'd like to do is offer my client to answer questions to the members of the board, because I think at this point that would be more useful, because they've heard, first of all, they've seen that there's been 2 hearings, and they've seen his transcript of his testimony, and I think they may have follow-up questions, and he's willing to answer any questions that you may have and tell you what he's doing. And so I offer that to the board.
Thank you very much, Mr. Sloat. So Dr. Amorn, what I will do is I'll swear you in as a witness, just so you're under oath, and then I will invite the members of the panel to ask you questions if they have any. So if you could raise your right hand, I'll swear you in. Do you solemnly state under penalty of perjury that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. And could you just state and spell your full name for the record, please?
Sure. My name is Allen, Allen, Amorn, Amorn, and with a middle name of Michael, Michael.
Thank you very much, Dr. Amorn. All right, so I'm now going to turn it over to our panel members to see if they have any questions. Let me start with you, Ms. Lubiano. Do you have any questions for Dr. Amorn?
Thank you. A few questions on my end. So the first, I saw that you weren't planning to come back to California to practice?
That is correct. So my wife and our family have been settled in the state of Ohio now since 2014. We are currently living by my sister-in-law, and we have a significant family support in the area. So I'm very pleased, obviously, to have been able to reunite with them back in Ohio, where we had originally planned on raising our family. The interest, certainly in regards to the early termination of the licensure, is, as Attorney Sloat has kind of pointed out, which is to make certain that it would not jeopardize my current state licensure and or federal program participation. So that is correct. I'm currently living in Ohio, have no plans to return to California. We certainly enjoyed, living and training here, received impeccable training here in California, but for personal reasons, have no intention of returning to California.
Got it. And to follow up on that about kind of the consequences on the federal level, what does that mean? Like,
I don't know that I'm well suited to answer the entire litany of potential downstream consequences of that. However, what has been explained to me certainly is that there is risk that a revocation of licensure in the state of California would result in my elimination from ability to practice, not only in California, but in all states throughout the United States.
And if I could also add to that.
please.
So whenever a license is revoked in California, whether it be medicine or nursing, the Department of Healthcare Services excludes that practitioner from Medi-Cal, which is a Medicaid program, right? Now, they do it very aggressively. So even when a nurse who is not a provider, because only advanced practice nurses are providers, But we have litigated the issue where they exclude nurses who are not providers. They just exclude you if you're revoked. And they put that out on the blacklist. So it's an exclusion list, and it goes to every facility in the country. And then what we see is that CMS picks that up and starts their case. And then the OIG, Office of Inspector General for the Department of Health and Human Services, does a similar process. That's the scariest one for us because it's broader than Medicare. CMS is an exclusion from Medicare based on the Medi-Cal exclusion. The OIG exclusion is from all federal health programs, and that includes military-related practice, and it includes the VA. So obviously, that's our most major concern, and that's why we want Dr. Amorn had to complete the process in California, could not surrender his California license, even though he has no intention of practicing in California.
Thank you. No further questions on my end. Fellow board members?
Thank you, Ms. Lubiano. Let me see, Dr. Hawkins, do you have any questions for Dr. Amorn?
Yes. So, Dr. Randy Hawkins, Dr. Martin, thank you for your commitment to patient care and to your family. I have two questions. One is, why did Dr. Keck decide to discontinue your medications? And a corollary to that would be, what tools do you have to assess your mental status off of medications?
Thank you, Dr. Hawkins. Both excellent questions. So the main reason for termination of my most recent medication was because of some of the unintended consequences and side effects regarding side effects. As someone who performs surgical procedures, I did find that some of my fine motor skills were less than what I had hoped they would be once I'd started the new replacement medication. And so removal of that medication has provided elimination of some of those side effects. But of course, medication is one piece of the puzzle when we're talking about mental health care. And so I certainly have an ongoing relationship with a therapist that I've been seeing now in approximately 3.5 to 4 years at this point, which I see at least on a monthly basis, if not sometimes even more frequently than that. I have Dr. Keck. I have a number of family members, both locally and obviously throughout the country, that are additional eyes and ears in regards to my own mental health. Because certainly one's own judgment of mental health is one perspective, but having outside perspectives is equally, if not more important, ultimately, when we talk about monitoring for signs and symptoms of depression or any other kind of mental illness. And so really it's been about building kind of that mesh network of individuals, kind of the Swiss cheese model, to make sure that there are no gaps that could not be picked up basically by, if not myself, friends, family, professional mental health, practitioners who basically have eyes and ears on me, on a constant and ongoing basis, which I intend on keeping lifelong.
Thank you. No question.
Thank you, Dr. Hawkins. Dr. Bolat, do you have any questions for Dr. Amorn?
No, I don't, Your Honor. Dr. Hawkins asked the critical question that I had wanted to ask. Thank you.
Perfect. Thank you so much. And then I think Dr. Tsai, do you have any additional questions for?
Yes, thank you. Thank you for being here, Dr. Amorn. I know you're busy as always. I only question, and I'm glad I'm able to ask this because from the written briefs it's not addressed. When you entered the stipulated agreement to be on probation, you were aware that there was an in-state practice requirement, and yet you agreed to that. And of course, you mentioned that since 2014 you were in Ohio. Did you foresee this sort of conundrum, this dilemma that you would have to address, or was this something that, well, we'll deal with it down the road?
Can I just? Of course. He didn't agree. Sorry, we didn't enter into an agreement. There was no stipulation. We went to hearing, and we asked the administrative law judge not to impose probation because Dr. Amorn was out of state. And we asked instead for a public reprimand. And the administrative law judge decided to issue probation for 35 months instead. And that was the decision, and it was adopted by the
I
board.
see.
And we had no power to do anything other than to do the best, comply.
Thank you.
Was that your only question, Dr. Tsai? I just want to make sure you were finished.
Yes, no further questions.
All right, terrific. Any other board member wish to ask anything else? I'm not seeing it. Thank you so much. I really appreciate your time. That concludes the arguments in this matter. The record is closed. Case is submitted for decision, and we are off the record in this matter. Ms. Lubiano, I'll turn it over to you as to whether we just proceed to the next petition straight away or however you wish to proceed.
Yes. Thank you, Judge.
Thank you.
Thank you very much.
Item number 4 on the agenda is oral argument for Dr. Is it Bagge? Bagge? Thank you.
All right, we are on the record before the Medical Board of California, Department of Consumer Affairs, State of California. We're here in the matter of the accusation that was filed against Lynn and Bagge, MD. This is Physicians and Surgeon Certificate number A67930, Medical Board of California case number 800-2020-072-633, and the OAH case number is 2023-110-096. Today is November 29, 2023. It's approximately 9:21 a.m. This is the date and time set for oral argument in the notice of hearing for oral argument. We're conducting the oral argument in person and by WebEx video conference. My name is Wim van Rooyen. I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over the oral argument today. Previously during the meeting, we have taken a roll call of board members, and we do have a quorum of board members present to hear the oral argument this morning. May I please have appearances of counsel, starting with the Attorney General, please.
Good morning, Your Honor. John Gatschet, G-A-T-S-C-H-E-T, appearing on behalf of the complainant in this matter.
Good morning to you, Mr. Gatschet, and then on behalf of the respondent, please.
Yes, good morning, Your Honor. Brad Wishek, W-I-S-H-E-K, appearing on behalf of the respondent, Dr. Lynn Ann Bagge.
All right, good morning to you, Mr. Wishek, as well. Thank you for being here. So in this matter, the board issued an order of non-adoption of the proposed decision by an administrative law judge in this matter and set this matter for oral argument before the board's panel A. The following process and time limitations will apply as set forth in the notice of oral argument. First, respondent will have 15 minutes to make an opening argument. Following that, the Deputy Attorney General will have 15 minutes for his opening argument. After that, the respondent will have 5 minutes for a closing argument, and then the Deputy Attorney General will have 5 minutes for closing argument. These time limits will be strictly enforced. I will provide you with a courtesy warning of about 1 minute before the time ends, but again, counsel, it's your responsibility to make sure that you comply with the time limits. The argument shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence, so no new evidence will be heard. The panel members may ask questions of the parties to clarify their arguments, but may not ask questions that would elicit new evidence. Either I or any panel member may ask a party to support the party's oral argument on a matter with a specific citation to the record. At the end of the oral argument by counsel, I will offer the respondent physician an opportunity to address the panel if she chooses to do so. Then I will place her under oath. Court reporter is present to record the proceedings and make a record for future purposes. After oral argument, the board will go into a closed session to deliberate. The parties will not receive a decision today, but will be receiving it in the mail at some point in the future. And I'll just again remind the parties that all arguments must be based on the existing record and that no new evidence will be heard. As a reminder, the board has already had the benefit of reading the briefs, but you can certainly highlight any particularly pertinent portions during the oral argument. With that said, I will turn it over first to you, Mr. Wishek, for your opening argument, and your time, your 15 minutes starts now.
Judge, thank you. I did have a housekeeping matter before we commence. We filed a separate motion to admit a document that was not a part of the record And I'd like to just have a ruling on that motion if we may.
We can't hear you, Judge.
Thank you very much. Thank you very much. I just stopped your time since it doesn't go to the merits, just so we can address that matter. Mr. Gatchett, did you have a response to that motion?
The object or the item that was introduced was a certificate of completion of the ethics course, which was actually part of the proposed order by the ALJ. It was not something that could be presented in the record during the hearing. I have no objection to its admittance, but I didn't have the power to admit that. At the end of the day, it's up to the board whether the board wishes to admit that document into the record. So with that, I'll submit on behalf of the complainant.
Thank you very much, Mr. Gatchett. Given that there's no opposition, and I think it would aid the board's decision-making, I will admit the additional documents. So the motion is granted, Mr. Wushek. Thank you. With that said, I will now start your clock for 15 minutes of oral argument right now. Thank you.
Thank you, Judge. Good morning. My name is Brad Wishick, and I have the honor and the privilege of representing Dr. Lynn Bagge. I want to begin by thanking this panel in the notice that was sent concerning this argument to encourage, the notice encouraged Dr. Bagge to appear personally as opposed to on WebEx so that she could meet the agency. That was the words, but of course the agency in this circumstance are the members of this panel. I have missed appearing in person in hearings. And it's because I think that there's something that can be lost in that process. And we've all done the best that we can. But by encouraging Dr. Bagge to be present, I think with the important decision that this panel has to make, that you deserve that opportunity to see and hear from Dr. Bagge in order to make this important decision. And I feel confident that when you have the opportunity to do that, that you will come to the conclusion that this was an isolated mistake in judgment, that she is not a substance abusing licensee and does not have a substance abuse problem, and that the discipline that was in the proposed order is sufficient to protect the public. And that is the issue in this case. We were directed, both of the parties, only to address in our written argument and in this argument today, whether or not the discipline that was ordered in the proposed decision was sufficient to protect the public. Dr. Bagge at the hearing never suggested that she did not subject her license to some discipline as a consequence of her conviction and the underlying conduct for driving under the influence. The lawyers agreed at the outset of that hearing that the only issue was what was the appropriate discipline in this case. And so here we are again with that very question that's appropriate for this panel to ask under the circumstances. And really, I think to answer that question, what you need to know is this a one-off? Is this something that a very talented, dedicated physician made a one-time error in judgment that was serious, but that's been remediated and that you will never see her again for this or any similar conduct? Or, and this is why this board and this panel's job is so important, is this conduct something, as it is in some cases, that is symptomatic? It's a red flag. It's an issue that says we have to look deeper because in this case, perhaps this physician has a substance abuse problem, such that the only way that the public can be properly protected is by subjecting the doctor, in this case, Dr. Bagge, to probation with rigorous conditions of monitoring that are appropriate and mandated now by law and the regulations of this board for substance abusing licensees. Now, when I was thinking about this record, and as Dr. Bagge's advocate, thinking as I go through the record, what is it that I should argue as her advocate to the members of this panel to answer that question? And as I thought about it, what I realized was this board should be much less concerned with what I have to say as an advocate and much more concerned and can take much more guidance from what it is that the administrative law judge, Marcy Larson, found, because she made numerous findings of fact that are supported by the record in this case. And it really occurred to me that Judge Larson's decision as findings of fact, not an argument from a lawyer, is far more persuasive on this issue than anything that I could say as an advocate. What she concluded in this decision was the following. Applying the board's criteria, respondent's lapse in judgment, which resulted in her conviction, was serious. She drank alcohol, drove a vehicle with a BAC over twice the legal limit, and hit another vehicle. When asked, she told police officers that she had one glass of wine before driving. This was false. Respondent demonstrated incredibly poor judgment. Although she did not feel intoxicated when she made the decision to drive her vehicle, she should have been aware that the amount of alcohol she consumed made it unsafe for her to drive. However, the evidence demonstrates that the respondent's conduct was an isolated incident of poor judgment for which she is deeply remorseful. When faced with the gravity of her conduct, respondent took full responsibility and clearly dedicated herself to making amends. Fully acknowledging the wrongfulness of past action is an essential step towards rehabilitation. As a result of her efforts, she was relieved of criminal probation almost 2 years early, and her conviction was dismissed pursuant to Penal Code Section 1203.4. Respondent has continued counseling to ensure that her mental health is strong so that she can provide the best care for her patients. She submitted to an evaluation with Dr. Sander to ensure or assure the board that she does not suffer from a substance use disorder. She is also mindful about consuming alcohol and is committed to never again drinking alcohol and driving a vehicle. Respondent has also been forthcoming to her colleagues and friends about her mistake. Her character witnesses and authors of the letters of support all attest to the deep remorse that they observed in respondent when she shared her conviction. Her willingness to disclose to others her mistake further demonstrates her commitment to be accountable. Most notably was the overwhelming evidence presented through respondents' witnesses and character letters that for over 2 decades, respondent has served as an exceptional physician and leader. The testimony and letters are further supported by respondents' performance evaluations and patient satisfaction reports, which demonstrate respondent cares deeply for her patients. And she strives to provide the best care. Her clinical judgment and competency have never been questioned. Complainant contends that a single DUI establishes respondent is a substance abusing licensee, which requires the imposition of probation with terms to monitor substance abuse. However, respondent convincingly rebutted the presumption that she is a substance abusing licensee. Dr. Sander was the only expert to testify and offer an opinion concerning this issue. He persuasively opined that respondent does not meet any of the criteria for a substance use disorder as defined by the DSM-5. Rather, his opinion is consistent with the evidence presented that respondent's conduct was an isolated incident and she does not pose a risk to the public or to her patients. Additionally, complainant's contention that respondent's false statement to the police that she drank 1 glass of wine before driving constitutes unprofessional conduct was also not established. She was intoxicated and scared. Her judgment was poor. However, her false statement does not demonstrate that she is unfit to practice medicine. Judge Larson concluded with the following finding. Respondent has a 24-year history as a remarkable physician, leader, colleague, and friend. She is adored by her patients. She is admired and respected by her friends and colleagues. She has lived a life of service and leadership. Respondent made a single isolated mistake that she will not repeat. When all the evidence and the board's disciplinary guidelines are considered, protection of the public does not require that respondent be placed on probation. Respondent does not need monitoring, and no benefit would be gained by requiring respondent to serve a period of probation. Therefore, the most appropriate discipline to be imposed in this case is a public reprimand with a requirement that she complete the 6-month ethics course follow-up and pay the board's cost. Those are the findings of Judge Larson. Judge Larson is a very experienced administrative law judge. I know she has sat with members of this panel in hearings just like this in the past, so that some of the panel members at least are familiar with and know her. She listens to the evidence over the course of 2 days, and she reviewed hundreds of pages of exhibits that were presented by the parties in this case. The law says that these findings of Judge Larson are entitled to great weight by this panel. That is Business and Professions Code, Section 2335A1. And why is that? What does that mean? Well, obviously, the important work that this panel does, you can't have an opportunity to sit through a hearing like Judge Larson did. But when there's a non-adoption, you have this opportunity at least to go back, and the law requires before a vote could be made to increase the penalty, that you've reviewed the entire record, including the transcript and the exhibits. But the idea, obviously, is that this board has to, under the system that we have, give deference to the findings that were made by the judge who had the opportunity to hear, see, evaluate the credibility of the witnesses. And appropriately, in this case, you're now going to have an opportunity to hear from Dr. Bagge, just as Judge Larson did. And I'm confident when you have that opportunity that you will reach the same decision and the same findings that Judge Larson did, and that you will conclude that a public reprimand is adequate to protect the public in this case.
Thank you very much, Mr. Wishick. Now, Mr. Gatchett, your opportunity to give an opening argument. 15 minutes starts now. Thank you.
Thank you, Your Honor. Members of the board, I don't think I'll take 15 minutes. I do want to talk, though, with counsel's ending there. The proposed decision was non-adopted by this board, so the board can make the determination. And the ALJ's credibility determinations are given great weight, but at the end of the day, it's up to this board to review the record, and the ALJ's final decision has absolutely no impact on what this board decides to do in this case. So I just want to make that clear. Council started with, is this a one-off or is this a warning sign? And to be candid, we really don't know. It was very clear in this record that Kaiser did not mandate, and her probation with the Criminal Justice Department did not mandate that she go through ongoing alcohol testing, that she go through group therapy, and that she have a clinical assessment done by an independent clinician, a neutral clinician. The clinician that did an alcohol assessment was hired, paid $600 an hour by the respondent to come and testify on the respondent's behalf. When you go through the proposed decision, at no point did the ALJ actually cover some of my cross-examination of that witness, what they were paid. And also, I think, as I pointed out in my brief, one of the biggest pieces with Dr. Sandor, he's never found a doctor to be a substance abusing licensee. Even on cases where a doctor was presented with 2 DUIs, he did not find that to be a substance abusing licensee. That was clearly in the record, and that was established. We do know a couple of things. We do know, according to the respondent, that she had issues with alcohol in 2008, around the time of her divorce. We do know this, the facts are undisputed. She committed a DUI. It was a high BAC DUI, 0.19. was the conviction entered. So she was more than 2 times the legal limit. We do know that she lied to the officers. She told the officers she'd had a glass of wine. She even followed that up with, when asked, well, what was it? And she said Sauvignon Blanc. And we do know that that was not the case. She had actually gotten home from work that night, and in about an hour and a half had drank 3 glasses of gin before driving. So we know that we know that. And we know that she started to drink again. That came out at hearing, that she on her own has decided to start partaking in alcohol. So even though this would have been a wake-up call for a lot of people to get a DUI conviction, impact your career, never touch alcohol again, we know that she's decided that she believes she's safe to drink. So really, when you're looking at it, what is probation? Probation is the attempt to ensure that the board knows that the person is safe to practice, okay? And that was the legislature's entire intent when they passed BNP 315, which required boards to begin treating substance abuse licensees with significantly more care and concern to protect the public, which, as the board members know, that's the entire point of board discipline, to protect the public. It's not here to punish the licensee. We're here to rehabilitate the licensee, and if we can do so with terms and conditions of probation that protect the public, that's the mandate of the board. The board has regulations, which we entered into evidence: 16 California Code of Regulation 1361.5, which requires that the board presume that the licensee is a substance abuse licensee based on the DUI conviction. We entered into evidence in the record the Griffiths, Watson, and Walker decisions, all of which show that a single DUI conviction can be a basis for discipline under BNP Professions Code 2229. And the board's own guidelines at page 26 specifically call for imposing probation. And that's what we asked for in the record. We asked for the minimum terms of 5 years probation. We asked for alcohol testing. As I noted to you, at no point did Kaiser or the criminal probation for this licensee ever put her on mandated alcohol testing. It requires her to abstain from alcohol. It requires her to undergo a clinical diagnostic evaluation by an independent physician appointed by this board. And those are the terms that are designed to ensure that public safety is upheld when we have a licensee who has gotten a DUI. A public reprimand is not in line with the board's disciplinary guidelines on this matter. As we noted, and as I've stated now twice, she was never in a structured rehabilitative environment, and she completed the bare minimum as required by the law, because the Criminal Justice Department only requires the bare minimum for DUIs, but the medical board should require more than what the criminal justice system requires, because unlike most people who don't have patients' lives at stake, a doctor does. And so that's why the terms of the medical board should be more significant than criminal probation. And so with that, we'd ask that the court, or we'd ask that you, the medical board, impose its own disciplinary guidelines in this case and impose probation in this case. And with that, I'll submit.
Thank you very much, Mr. Gatchett. I want to give you an opportunity for any reply argument. If you wish, Mr. Wishick, 5 minutes. It starts now.
Thank you, Your Honor. I really have to strongly disagree with the argument that's just been presented with regard to the findings of Judge Larson. Those findings by statute are entitled to great weight under the terms of 2335, unless there's some new evidence to controvert that. What I have not heard from counsel for complainant is that those findings that were made by Judge Larson are not supported by the evidence. And the reason that we haven't heard that argument is because reading the transcript and looking at the exhibits in this case, it's crystal clear that all of the findings that she made are supported by the evidence of this case. If complainant's argument were adopted by this panel, in effect, what I'm hearing is, well, we just can't ever be positive 100%. And therefore, anytime there's a driving under the influence case, we should impose probation without regard to whether someone is a substance abusing licensee. But when you look at this decision by Judge Larson, all of the criteria that are in the regulations are carefully addressed by her. And with regard to substance abusing licensees, there is a presumption. And the burden was on Dr. Bagge at this hearing to rebut that presumption. And that is the way that the legislature set up a protection and holding physicians and other healthcare professionals to a higher standard. To presume if discipline is warranted because that physician has engaged in some unprofessional conduct involving alcohol, that's the presumption. And the burden is on Dr. Bagge to come in and show, I'm not a substance abusing licensee. Those conditions are only appropriate for someone who is a substance abusing licensee. And I also take exception on this record to the suggestion that no one did anything. Judge Larson went through in great detail all of the steps that were taken by this physician. And I would say that she is a model for what we would want any professional to do. She approached this mistake in the same way that she approached her entire career as a physician that led her into leadership and to being a doctor that is the doctor's doctor. She accepted responsibility in the criminal case and before this board. She complied with every condition of her probation. She was rewarded with an early termination of probation. She disclosed it timely to this board. She cooperated by writing a letter to explain it, participating in an interview, and testifying before Judge Larson and being cross-examined. She submitted to an evaluation by Dr. Sander, and I have to take exception. I do not believe that the record states or that is supported with the idea that he has never found someone to be a substance abusing licensee. But the bottom line is she exposed herself to that evaluation to assure the board that she does not have a substance use disorder. With regard to Kaiser, to characterize her participation in the wellness program as something where she was essentially let off the hook is to really turn around a positive and try to make a negative out of it. She reported what happened, which is so hard to do, to colleagues and other leaders. She was referred to the wellness program, and the record shows that she spent months meeting repeatedly with members of the wellness committee whose obligation on behalf of patients in Kaiser was to evaluate what does this doctor need in order to be safe.
1 minute
for our
remaining.
patients. And she did everything that they told her to do. What that evidence is just like Dr. Sandor, the wellness committee didn't see a need for her to be completely abstinent from alcohol, to test, to be in a support group, because like Dr. Sander, they obviously concluded that she's not a substance abusing licensee. These findings by the judge are supported by the evidence. Absent complainant being able to point to you that the evidence is not on the record to support those findings, they are entitled to and should be afforded great weight, both as a matter of common sense and by law. And for those reasons, I urge the board to adopt a public reprimand based upon the findings of this case.
Thank you, Mr. Wishek. Mr. Gatchett, you have 5 minutes for a reply as well. It starts now.
Counsel and I agree a lot about most of the facts in this case. We just disagree significantly on what the appropriate penalty would be, and we have had that disagreement between our parties throughout the process. I would just note that the citations in my brief for the board are presented at page 9 and 10. And so the board has the opportunity to look at those citations and review the record. We'd ask that the board follow its disciplinary guidelines and impose probation in this case. Thank you.
Thank you, Mr. Gatchett. All right, Mr. Wishek, would you like to have the opportunity to have your client address the board directly?
It is my understanding that Dr. Bagge is anxious to have an opportunity to talk to the members of the panel. Thank you.
No problem. All right, so Dr. Bagge, You have that microphone near you. The first thing I'm just going to do before you give your statement to the board is swear you in. So if you can raise your right hand, I'll swear you in. Do you solemnly state under penalty of perjury that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you so much. And could you please state and spell your name for the record?
My name is Lynn Bagge, Lynn, last name Bagge, Bagge.
All right, thank you. And you may proceed with your statement to the board, Dr. Bagge. Thank you.
Thank you. Good morning, everyone, and thank you for giving me the opportunity today to be seen and to be heard. I'm Dr. Lynn Bagge. I'm an outpatient pediatrician, and I currently care for about 1,000 patients. I'm also an assistant physician in chief, and in that role, my job is to lead and inspire my teams of about 400 physicians and 600 staff to continuously improve the care that we provide for our patients. I'm proud of the 97 to 99% approval rating that I receive from my teams and, more importantly, from my patients. I take my job very seriously, and I hold myself to an exceptionally high standard, a high standard of excellence. And in this particular instance, I'm sorry I failed miserably. 3 years ago, on November 11th, I got behind the wheel of a car after having too many drinks, and I hit another car. Fortunately, there was minimal damage and nobody got hurt, but it could have been so much worse. I was arrested and I spent the night in jail with 20 or some other women who were there also after having had so many other DUIs. And as someone who's never been in trouble before, I was completely humiliated and completely terrified. When I made my statement to the police, I was so scared. I lied about what I had to drink, and I lied about how much I had to drink. And there I am sitting with these women and wondering, what am I doing here? What have I done? And worse yet, what happens to me next? So I decided I must accept the consequences, and I immediately enrolled in the first-time offender DUI course. So I spent 2 hours a week in a small cohort of people for a 6-month period. I had a interlock ignition device installed in my car so I could drive to and from work, blowing into a breathalyzer device, and occasionally when the alarm goes off, having to pull over to the side of the road and blow into the device and pray that nobody would see me. I spent a week at home on detention, wearing a big old ankle monitor, and again, submitting random breathalyzer samples 4 to 6 times a day and having my photo taken. And I met twice a month with the Physician Wellbeing Committee before and after work. I met with my therapist who helped me work through my feelings of guilt and shame and fear and stress. And I continue to work with her to this day. I did complete that professional ethics course, including the 6 and 12-month follow-up. And ultimately, I was granted early termination of my probation, and my case was dismissed. I have learned a lot from my mistakes. I've been completely open and honest and transparent through this entire process. And I sought professional advice and guidance from Dr. Sandor, who concluded that I do not have a substance abuse problem. I have learned a great deal and a great depth of empathy now for my patients, my families, my colleagues who struggle, who have also made mistakes. And I've learned how to hold space for them and to give them grace in a way that I hadn't understood before. And it reminded me of my role as a physician, how important it is as a role model, as a pediatrician, and the importance of professionalism, because yes, physicians should be held to a higher standard. I'll never forget what I did and everything that I've gone through. And in fact, I have the opportunity to be reminded on a daily basis in my practice when I meet with patients and families, and I counsel them about how to keep their children safe and healthy. And I talk to teenagers about how to make safe decisions, and especially about drinking and driving. I'm very clear about what my job is going forward. Judge Larson did an excellent job, phenomenal job of reviewing my case and giving a thorough and thoughtful and detailed response. And I know it's the board's job to ensure the safe practice of physicians in our state. So thank you for your service, and thank you for carefully considering the details of my case. I'd like to share a little story. My patients now grow up. They turn into adults. They go off and have their own families, and they bring their children to see me. And yesterday I was in with a lady who was previously my patient, and she brought her 5-year-old in for a well child checkup. And I asked her daughter, "Hey, you're 5. What is the best thing about being 5?" She looked up at the ceiling and she said, "Going to school." And then she looked over at her mother and she said, "Playing with my mommy." And then she looked over at me and she said, "Going to the doctor." And there she was in her unicorn sparkly shirt and her sparkly little tennis shoes. And I thought, well, gosh darn, if out of all the things about what is best about being 5 and I made the top 3, I must be doing something right. So in spite of this terrible, horrible mistake and everything that has happened, I promise it will never happen again. I have learned so much. This experience, I know, has made me a better person, and I'm grateful for that. Thank you for your time.
Thank you, Dr. Bagge. I now want to give members of the panel an opportunity to ask you questions. So starting with Ms. Lubiano, do you have any questions for Dr. Bagge?
Yes, just one. Thank you. I saw in the record that after the incident, you had stopped drinking for about a year or so and now socially on occasion. Is that still the case?
That is still the case.
Thank you. No further questions.
Thank you, Ms. Lubiano. What about you, Dr. Hawkins?
Yes, thank you, Dr. Hawkins. Thank you, Dr. Bagge. So it's clear about your impeccable career service, your patients, and the esteem in which your colleagues and patients hold you. And that you've learned a lot. It's hard to imagine not learning, but sometimes we do see that. Can you tell us a little bit or expand a little bit about what you believe the nexus exists between decisions we make in our personal life, such as one that happened with you, unfortunately, and the practice of medicine? You have a comment about that?
I do, yes, I do, because of my experience in the professional ethics course, I've come to a greater understanding about what that is, about the importance of medical ethics and professionalism, and the importance of overall professionalism when it comes to physicians, that how we conduct ourselves in our social lives is very much a part of the role that we play as a member of the community. So I do see that the two are intimately intertwined. It is more of just a connection. It is a necessity. It's a commitment. And I understand that now to an even greater degree.
Thank you. No others.
Thank you very much. Dr. Bolat, any questions?
Yes, thank you, Your Honor, and thank you, Dr. Bagge, for your service to those children that grow up to become adults and then come and see you with their children. Obviously, as a pediatrician, you are administering screening tests for your children as part of the well child check. Unfortunately, we're getting younger and younger having to check for substance use in our youth, right? And so, please tell me, Your Honor, and the rest if I'm going off the rail here. But when you have a patient that may be a young 16-year-old athlete, let's say, and he or she is, had a run-in with an alcohol problem, right? It happens. What kind of advice would you give now based upon your own experience for that use of alcohol or not use of alcohol?
Well, every experience is unique and different, and our teenagers face a whole host of stressors, not just as teenagers, but maybe what they've experienced as children. So there's a lot to process in that moment. And I think what's most important for me is to elicit the true and honest experience of that teenager, for example, or that child. Unfortunately, that's the case too. And understand what's behind that. What are they going through? What does it mean to them? And what will they do next? And then I have to offer to them, what is my role? And how can I help you in that process? I tell my teenagers, nobody can take care of you like you can. It's up to you. So help me understand what you need in order to do that best, because there will be a time when you don't have your parents, or maybe you don't have your parents now, quite frankly. And so for me, it's about taking in as much as I can at that exact moment in time. I can reflect on my own experience, and again, be empathetic in a way that I wasn't previously, in a way that I can be non-judgmental and I can be accepting. And I hope what that means then is that they'll engage with me about whatever this instance is, but then also engage in a lifetime of taking great care of themselves, their health and their safety.
Thank you, Dr. Bagge, very much.
Dr. Bolett, are you satisfied? Any additional questions?
No, Your Honor, thank you.
Thank you so much. All right, Dr. Tsai, do you have any questions?
I don't have any questions. I just want to thank Dr. Bagge. It's always nice to hear your side of the story so that we can sort of actually understand what's going on rather than just words on a paper. So thank you.
Thank you very much, Dr. Tsai. Any other board member questions? Anything occur to you before we close the record?
No further questions.
Thank you very much. All right, then at this time, the oral arguments are concluded. The record is closed. Case is submitted for decision, and we are off the record in this matter. I'll turn it over to you, Ms. Lubiano, as to how you wish to proceed next on the agenda.
Thank you. The next item on the agenda is oral argument number 5 for Dr. Ebel.
All right, we are on the record before the Medical Board of California, Department of Consumer Affairs, State of California. We're here in the matter of the accusation against Valerie Jane Ebel, MD, Physicians and Surgeons Certificate number A132130, Medical Board of California case number 800-200-050-993, and the OAH case number is 2023-110-115. Today is November 29, 2023. It's approximately 10:03 a.m. This is the date and time set for oral argument in the notice of hearing for oral argument. We're conducting the oral argument in person and by WebEx video conference. My name is Wim van Rooyen. I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over the oral argument this morning. First, to ensure we have a quorum, we've taken the roll call earlier on during the board meeting, and we do have a quorum present to hear oral argument on this matter. May I please have appearances of counsel, starting with the Attorney General?
Greg Chambers with the Attorney General.
Good morning, Mr. Chambers. And then on behalf of the respondent.
Good morning, Ian Sharg on behalf of respondent Valerie Ebel, MD.
Good morning to you, Mr. Shark. Thank you. So in this matter, the board issued an order of non-adoption of the proposed decision by an administrative law judge in this matter and set the matter for oral argument before the board's panel A. As set forth in the notice of oral argument, the following process and time limitations will apply. First, the respondent will have 15 minutes for an opening argument. Then the Deputy Attorney General will have 15 minutes for his opening argument, followed by the respondent's 5 minutes of closing argument, and then the Deputy Attorney General having 5 minutes for closing argument as well. These time limits will be strictly enforced, and I will try and give a 1-minute warning if appropriate, but counsel, it's up to you to make sure that you stick to your time limits. The argument shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. Either I or any panel member may ask a party to support the party's oral argument on a matter with a specific citation to the record. At the end of the oral argument by counsel, I will offer the respondent physician an opportunity to address the panel. If the respondent elects to address the panel, I will place the respondent under oath. There's a court reporter present to record the proceedings and create a record for future purposes. After oral argument, the board will go into a closed session to deliberate. The parties will not receive a decision today, but will be receiving it in the mail sometime in the future. I'll just remind the parties that the board has had the benefit of reading your briefs, so but you're certainly welcome to emphasize any portions you particularly want to highlight for the board members. With that said, I'm going to turn it over to Respondents Counsel to do your opening argument. Your 15 minutes starts now.
Thank you, Your Honor. Good morning, ladies and gentlemen of the panel. Appreciate you all taking the time to allow us to meet you face to face. Obviously, much more engaging than being on how we've been for the past few years. So we appreciate the opportunity to see you all in face to face, and for the opportunity to meet my client, Dr. Ebel. She greatly appreciates the board's role, and the ability to meet the decision makers who ultimately are going to decide whether to adopt or not adopt Judge Reichman's proposed decision in this case. Who is Dr. Ebel? Dr. Ebel is a family practice physician. She has worked almost exclusively in rural family practice since she left medical school. She went to medical school, as the record shows, later in life. She was a volunteer in the Peace Corps and decided, hey, what am I going to do to better people's lives? And what better way to do that than to become a physician? She became a physician to help people, and that's what she's done since she's been licensed in the state in 2014. She began her practice post-residency at Mad River Hospital, which is up in rural Northern California in Eureka, which is a different practice than the traditional practice that she was used to at Sutter Santa Rosa, which is more of an urban practice similar to what we might see here in Sacramento County.
Mhm.
And in that practice, she began to practice obstetrics, which she did train in as a family practice physician at Sutter Santa Rosa, which gave her the ability to deliver babies.
Mhm.
And in 2017, which led to the accusation in this case, there was an unfortunate instance with where she was reliant on the nurse. The nurse was being onboarded without her knowledge, and when she was reasonably relying on the nurse to tell her, how's this tracing, while she attended to both this patient and another patient who was laboring in another room. And Dr. Ebel did the best she could. There's no evidence that the tracing of the fetal heart monitor was going bad. There was no way for her to anticipate that the baby would be delivered limp and without breathing. She participated in a neonatal resuscitation. They were able to somewhat resuscitate the baby and ultimately intubate the baby. She was not credentialed to intubate, so there was a time period in which they were bag and masking the baby, which was supported by our expert, Dr. Marvin Camrus, who said that was within the standard of care. Ultimately, in addition to that, she's presented evidence of her good character at the hearing. She had multiple character witnesses and letters of recommendation coming from various people, including nursing staff, physicians, friends, etc. They all spoke about how great of a physician she was. She delivered one of her colleagues' children. Now what she does is she's completely left because of this experience in dealing with Mad River Hospital, its problems, the problems with nursing staff. This experience has led her completely away from the practice of obstetrics. She had no complications before this unfortunate incident in 2017 with deliveries. She had no further incidents, over 100 deliveries post-incident, no complications whatsoever. So what she did to better the lives of people is she moved to Santa Rosa. She works in West County Health Center. She works, which is an FQHC, a federally qualified health clinic, and she provides medical services to migrants, homeless people, and drug addicts. And what she does is she's also in at her own expense, as indicated in the record. She's undergoing a 2-year integrative medicine fellowship to help better people. What does she do now? No obstetrics. She testified that she's never going to practice obstetrics again because of these experiences that she endured at Mad River. She changed her practice when she was doing obstetrics because of this incident to personally review every strip, to check in, to essentially micromanage the nursing staff, which she wasn't required to do ever. In the board's expert, Dr. Mabanugo, she agreed that it's reasonable to rely on nursing staff to interpret fetal heart tracings. And so now she works providing acupuncture to homeless people, migrant workers, outpatient family practice to help people who are underprivileged, underserved, medically indigent. And her current supervisor, Dr. Moore, testified that if she were to be placed on probation and not receive a public reprimand, well, then it's a real reality that she could no longer be able to do those services for the homeless migrant population of West Sonoma County. Because because of the county clinic being a FQHC, she's subject to, like what we heard in previous argument, the various rigors of CMS, and she could end up onto the exclusion list and be unable to provide care. And she would lose her job, and hundreds of patients who have no way of getting medical care would lose an excellent physician who's at her own expense striving to go through an integrative medicine fellowship 5 years after she's been residency trained in family medicine to help people get better. Now, I want to talk about the proposed decision. This was a 4-day administrative law hearing with Judge Karen Reichman. She is an extremely experienced administrative law judge. The board, under pursuant to Business and Professions Code 2335, is required to give great weight to her decision. And in the Attorney General's argument, the Attorney General is arguing that Judge Reichman's deviated from the disciplinary guidelines. And for that reason, Dr. Ebel should be placed on 5 years of probation with standard terms and conditions. In the guidelines itself, on pages 2 and 3 that the board is well aware of, the guidelines state they are guidelines. They are used as a model to be followed, but it's not necessary. If it is deviated from, it indicates that the judge shall indicate the factual support as to why he or she is deviating from the guidelines. And in this case, Judge Reichman, in her proposed decision, has specific factual support as to why she deviated from the disciplinary guidelines and recommended the board issue a public letter of reprimand. Specifically, what Judge Reichman said is this violation, as per the accusation, meaning the bad outcome in this case, which we're not denying is a horrible outcome, that a baby died. We're not disputing that fact at all. We're disputing that she was a cause of it. However, the violation occurred within her first year of practice post-residency. She's had no problems since then. Is at a rural facility, limited resources. She also did not know and was responded to and reassured by the nurse that the category of the tracing, fetal heart tracing, was appropriate. She had no reason to suspect otherwise. She was not found to be incredible by the judge. There's no credibility issues whatsoever. The judge believed that she had a good faith basis to rely on the nurse. She also had another nurse present for delivery. Now, she continued to practice for 4 more years. She changed her practice to be more of a quote unquote micromanager, which was used during labor and delivery. And then, because of the events and circumstances in this case, she changed her practice altogether to pursue an integrative medicine practice, as opposed to practicing in rural family practice with obstetrics. And she testified in hearing. She has no plan to resume obstetrical practice. She's based upon what the actions she's taken with going through a fellowship and what her current practice is. There's no risk to the public at all. Dr. Moore testified that she's an exemplary physician. She is excellent patient reviews, and she's relocated. The words that have described her as compassionate, competent, sound clinical judgment, and the Judge Reichman specifically found that it is unlikely that respondent will engage in any further similar acts of negligence. And even counsel for the medical board for the complainant suggested that a public reprimand would be warranted, given that Dr. Ebel has said under oath, I am not going to practice obstetrics ever again. And the evidence and her actions support that because of what she has done. I would urge the board to adopt Judge Reichman's proposed decision. There is absolutely no risk to the public that she is going to commit any further acts of unprofessional conduct or negligence in any way. She has completely moved on from the practice of obstetrics, and she poses absolutely no risk. In fact, there's a greater risk if the board places her on probation, that patients are going to lose an excellent physician who takes care of them in an underserved community. That risk is far greater than any risk to the public of her practicing obstetrics, which she's not going to do anyway. And with that, I will submit.
Thank you, Mr. Shark. All right, Mr. Chambers, your opportunity to provide your opening argument, 15 minutes starts now.
Thank you, Your Honor. The board should reject the proposed decision. What we heard was a little bit disturbing, frankly. The idea that the rural population should get a physician who refuses to admit that she had a hand in the death of the child after there was a finding of a simple departure from the standard of care for failure to acknowledge and act on the fetal heart monitoring, and for failure to oversee and ensure resuscitative care of the newborn. And that second one was an extreme departure from the standard of care. The ALJ, pursuant to Business and Professional Code section 2335, is supposed to be given great weight in their opinion. However, that doesn't mean blind obedience to that opinion. So let's take a good look at that opinion. To support the public reprimand, the ALJ provided some justifications. The first was that the events occurred during respondent's first year of practice. The respondent altered her practice. There have been no further allegations of negligence. Respondent stopped providing obstetrics and relocated. And that counsel, who appeared at that hearing, suggested that a public reprimand as opposed to probation might be warranted. Well, first, when negligence occurs in the first year or 5th year or 20th year of one's practice is not relevant. Negligence occurs. The question is, what do we do about that negligence? How do we address it to make that practitioner safe for the California consumer, or in this case, those who are in a rural community? Second, that respondent has stopped providing obstetric care for now is fine. A respondent is not precluded from returning to the practice of that discipline. She can begin tomorrow if she wanted. That's not acceptable under these conditions in this fact pattern that we've received. If she were to resume obstetric work, it would need to be oversight and monitoring. There was a statement in the proposed decision that counsel for complainant had suggested that the public reprimand might be appropriate, but there was a qualifier in there, and that's important, and I noted that in our moving papers. The attorney's statement was actually prefaced with the requirement that the ALJ find respondent's clinical judgment no longer be in question. And there's a specific site for you to turn to. The ALJ never found such a finding. And in fact, we have just the opposite. We have a licensee who testified that she didn't think she made a mistake on the day in question. Her expert didn't think she made a mistake on the day in question. Yet the ALJ, in the proposed decision, said she gave greater credence on this issue to the medical board's expert. To this day, respondent or the licensee doesn't believe she made a mistake. That's troubling, and it's troubling for the people that she serves now in the rural communities. What else isn't she going to think she made a mistake on? So yes, there was a deviation from the medical board guidelines, and on pages 2 and 3 of the guidelines, there can be deviations. But the deviations are not justified in light of the facts that were presented at hearing. And subsequently, this opinion, this proposed decision cannot be accepted and adopted. With that, we also note the Zuckerman factors were addressed and costs were reduced because this was considered a public reprimand. Well, it was gross negligence and civil negligence found by clear and convincing evidence. The judge just deviated from the requirements there, and we believe that all costs should be afforded to the board once you afford the facts and the evidence the weight that they truly should be given in this case. Thank you.
Thank you, Mr. Chambers. I'll return to you, Mr. Shark. You have reply argument 5 minutes. That starts now.
Thank you, Your Honor. I just want to address a couple of points made by Mr. Chambers. First, to characterize that Dr. Ebel is not taking responsibility is a gross misstatement, and to call it disturbing is abhorrent. She had a good faith belief that there was adequate oversight and monitoring, and the board's expert says, quote, that it's reasonable and within the standard of care to rely on nurses and to assume that they're trained. She didn't know that someone was not trained until much later, and the nurse who was supposed to be training her was terminated for not overseeing this new nurse, Miss Snook. And an unfortunate, and in terms of the other issue, in terms of the gross departure for the purported failure to oversee a resuscitation was being handled by the nurse, a very experienced nurse who came in to help with the delivery, and a respiratory therapist. Dr. Ebel was attending to the patient and had to deliver the placenta. She can't abandon a patient And also, she can't be in two places at one time. In other words, she can't be abandoning the mom who's delivering a placenta and also watching someone provide bag and mask to an infant. The bag and mask, whether that's being handled by her personally or a respiratory therapist or a nurse, is irrelevant. And the other part that I take issue with Mr. Chambers' comments, like that, oh, well, she could go and practice obstetrics tomorrow. His statement is inferring that Dr. Ebel perjured herself when she says, I have no intention to return to obstetric medicine. And the facts are supporting that she's not going to do that. Why would she spend tens of thousands of her own dollars to go through with an integrative medicine fellowship? Why? Because she's going to go back to obstetrics tomorrow? No. That in and of itself is clear and convincing evidence that she's not going to return to obstetrics. She moved away from the hospital where she was practicing, and she's practicing with zero restrictions whatsoever, not a single patient complaint, not a single adverse outcome, and excellent remarks from her coworkers. To say, well, she needs oversight in obstetrics because she might go tomorrow, leave here, and then go get a job delivering babies, that is just a ridiculous assertion to make. And that's not what the evidence in this record supports. That is an inadmissible statement. Next, she has been shown time and time again to have excellent judgment by both her colleagues that she worked with at Mad River Hospital, people who have testified on her behalf in the record, people who submitted letters of support, and in addition to her own testimony. And then her supervising physician, Dr. Moore, reviews her charts and testified she has sound clinical judgment, compassionate, and competent. That's not evidence that she's a danger to the public. In fact, she's an asset to the public. To suggest otherwise is erroneous. Lastly, with regard to the Zuckerman versus Board of Chiropractic Examiners 29 Cal 432, the standards for which whether to reduce or impose the full cost award on a licensee.
1 minute remaining.
Thank you. Those standards include whether they're successful in getting the charges reduced and or whether that licensee had a good faith belief in the merits of her position. She doesn't think she could have done anything differently. It was a complicated patient. She did the right thing. She reasonably relied on the nurse, and she had an expert who's the director of high-risk pregnancies at Mercy San Juan Medical Center here in Carmichael, who supported her and said she did everything within the standard of care. And for that reason, we would urge the board to reduce the costs to $3,400 as indicated in the proposed decision, and to adopt the proposed decision as a public letter of reprimand. To do so otherwise and place Dr. Ebel on probation would be a miscarriage of justice. So thank you all.
Thank you, Mr. Shark. All right, Mr. Chambers, you have 5 minutes for a reply argument starting now.
We heard yet again that the licensee does not believe that she's done anything wrong and that she would not have done anything differently. That's troubling. We're told that she has excellent judgment. Facts belie that statement. The facts are before you. The justification to get down to a public reprimand were undone. This is not a public reprimand case. It's very straightforward. I thank you for your time.
Thank you, Mr. Chambers. All right, Mr. Shark, would you like to have the opportunity for your client to address the panel directly?
Yes, please.
All right, Dr. Ebel, if you can, I think you're sitting close to the microphone there. First thing I'm going to do is swear you in. So if you can raise your right hand. Do you solemnly state, under penalty of perjury, that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you so much. Please state and spell your full name for the record.
Valerie Ebel, Valerie, last name Ebel, Ebel.
Thank you, Dr. Ebel. You can proceed with your statement to the panel. Thank you.
Thank you. Good morning, everyone. Thanks for having me here and listening. It would be hard to overestimate the effect that this case had on my life, both professionally and personally. And being a new physician and having an outcome like this, and attending a birth, and then going through the resuscitation to have this baby die changed my life. And that's not an understatement. His life and death taught me a hard truth that where I was practicing obstetrics in this hospital was very different from where I was trained less than a year prior in residency. And I had to change what I did. I wasn't aware going into it that was the case, and I was practicing as I was trained. And I did change how I practiced, and I continued practicing obstetrics for 4 years after this case. I spent the night in the hospital rather than relying on the nurses as as was appropriate and as we could do, which was be at home in bed if someone was laboring, and the nurse would report the strip to you. I very frequently chose to sleep in the hospital rather than rely on that. We did not have central monitoring in that hospital, so you had to be in the room to look at the strip, and I would make sure I was the one looking at it from this case on. I had a very low threshold of calling in the pediatrician to be there for delivery if I had any concerns, which is hard there because we don't have that kind of staffing in that hospital. We didn't to make that a reliable and regular resource. So professionally, I changed from that moment on. And again, I practiced for 4 years after that and delivered, I think, over 150 babies safely and without incident. And I stopped practicing obstetrics in August of 2021, not because of this case specifically, but because of this as an example of the kind of safety issues at this hospital. And there were many others that finally I couldn't practice at this hospital anymore. I had always had an interest in integrative medicine. And so during the time that I was doing obstetrics, I also trained in acupuncture. And just in October of this year, I completed a 2-year fellowship in integrative medicine that was at my own cost and my own time. And the reason is because people come to me all the time as a family medicine doctor and want to know what they can do to be healthy and to take care of themselves without surgery or taking a lot of pharmaceutical medications that they're afraid to take. And I didn't have the answers. I didn't learn that in medical school, and most of us don't. And so I took it upon myself to learn this so that I would know and that I could help people. And I've just completed that training, and people are so grateful for that. And this is the practice that I intend to continue for the rest of my career. Frankly, you couldn't pay me to go back to obstetrics. I had really wonderful experiences with the families that I took care of there, and whose babies I delivered, and then who brought their kids to me for their well child checks. That was really special and meaningful to me, but it's not what I'm ever going to do again in my life. I will not practice obstetrics. And so I intend to have an outpatient practice. And I still practice in a community health center, and I do offer integrative and acupuncture services to anyone. We take any patient who comes, regardless of insurance. And then on a personal level, I just wanted to say that the tragedy of this baby's life and death kind of forced me to find ways to make peace with the past that you can't change, but to try to use it to some good and remain a positive, hopeful, and optimistic person for the future, and to grow from that. And I have done that, and the experience has made me a more compassionate and understanding person and doctor, and to slow down and to see the gray in situations and to withhold blame and judgment. And I also went through some EMDR trauma therapy after this as well, which helped a lot because I was having a lot of nightmares and related to this case. And so my own personal journey after this baby's death, now more than 6 years ago, has changed my life, and I believe for the better. And I think that I'm able to offer medical advice and support and services to people that is unique and is a benefit to society. And I attest that there's nothing from this isolated case that happened more than 6 years ago that poses a threat to the people of California or anywhere else I would practice. So thank you for listening.
Thank you, Dr. Ebel. I'm now going to give the panel members an opportunity to ask you some questions. Starting with Ms. Lubiano, do you have any questions for Dr. Ebel?
I had a question for Attorney Chambers.
You can go ahead, Ms. Lubiano.
Okay. For this, if it were a public reprimand, have you discussed what it would say on that reprimand?
I have not discussed it with anybody from the board since the proposed decision came out. No, Your Honor.
Okay.
If that's, is that your question?
Yes.
No, I have not had this discussion with regard to this case with complainant or with anybody from this board or panel.
Got it. Okay. No further questions on my end.
Thank you very much. Dr. Hawkins, any questions?
Yes, thank you, and thank you, Dr. Ebel, for your comments. I apologize because my questions may be somewhat repetitious because I was thinking about them prior to you giving your statement. So you have an integrative medicine practice now that does provide service to some indigent populations that you mentioned. What's the rest of your practice? You talked a little about that near the end. I just want to hear what the rest of your practice is. And do you have what policy and procedure you have now for monitoring the supportive staff with those other parts of your practice? The second question has to do with, I'm a physician, we make choices about what we do, and we're influenced by our life experiences. I would like to hear a little bit more about, unless you think you've answered it comprehensively enough, why stop OB care now, given the fact that you practiced for 4 years after that. Presumably you might have developed a good supportive staff that you can trust. I'm just curious how you respond to those two. Thank you. I realize you answered some of it already.
Sure. The first question was as regards to my practice now. So I work at a federally qualified health center, a community health center practice with a few different physical locations in Sonoma County. I provide just general primary care practice at my main site. It's just conventional, regular primary care. And then 1/2 day a week, I provide acupuncture services to our patients at the community health center. And then another 1/2 day a week, I'm at a site that is for the unhoused population only, and that's a National Healthcare for the Homeless site. And I I do acupuncture there as well, but also it's sort of anything that walks in the door at that clinic. I trained in integrative medicine. It's a 2-year integrative medicine fellowship through the Academy of Integrative Health and Medicine out of La Jolla. It includes holistic practices like dietary and nutrition advice and supplements and acupuncture and traditional healing systems. So I just finished that in October of this year, and I incorporated as much as I'm able into the advice that I just give my patients. And then secondly, about obstetrics. So like I said, I got into a point with this hospital that I couldn't work there anymore. And it's a rural area, and there wasn't another place that I could do obstetrics. There's another hospital there, but they generally would only employ OBGYNs or midwives, not family medicine physicians. And so the question was, do I want to continue practicing obstetrics to a point that I would move to another place simply to find another hospital where I could practice obstetrics? And my husband and I just decided that there were other things that I was interested in doing in medicine rather than relocate the both of us to a place simply to continue practicing obstetrics. So that's why.
Thank you.
Mhm.
Was that any other questions, Dr. Hawkins, before I moved on?
No, thank you very much.
Thank you very much. All right. And then Dr. Bolat, any questions?
Yes, I do. Thank you, Your Honor, and thank you, Doctor. You went to a residency program and you were interested in full scope family medicine, I take it, and that included the obstetrical delivery of obstetrics, actually. And you've explained to us that for various reasons, you've moved your practice to integrative medicine. And as a family physician myself, who used to do obstetrics, I understand the challenges and the issues that happen, particularly in rural areas. And you work now in a FQHC community health center and doing various things with the unhoused. Do you still do prenatal care?
I don't. Our community health center has a separate OB team that it's sometimes hard to staff, and they've asked me numerous times to be a part of the OB team, and that's a firm no for me. So I do not.
Understand. And for those, and so you continued on after that tragic event. And can you tell us a little bit what drew you to obstetrics?
The intimacy of the personal relationships with the patients that I had, and I loved providing prenatal care and meeting. Oftentimes it'd be the whole family in the room, or other children, older children, and the partners, spouses, husbands. I loved being in that room, and I love those experiences I have with those women, and then postpartum as well. And I mean, once I moved away and I felt like it was more of a peer relationship, I've kept in contact with a lot of the families whose babies I delivered, and so just the experience of being able to support those people, and it was the personal experiences that drew me to it, and I find that I can have that in lots of other ways with patients too. I thought I would desperately miss doing obstetrics when I left doing it, and I've found that I haven't. I've just shifted my love of people and taking care of them and being with them through hard moments of their lives in a different direction.
And helping them heal through the use of your new toolbox.
I
So-
try. Yeah.
Okay. Thank you very much, Doctor.
Yes.
Thank you, Dr. Bolat. And then Dr. Tsai, did you have any questions?
No,
for
I don't
Dr.
have any questions. I'd just like to thank Dr. Ebel for showing up, because it's always nice to hear the person and their story. Thank you.
Thank you.
Thank you. Thank you, Dr. Tsai. Any other questions by other board members?
Dr. Hawkins, I had a question. I was just thinking about it. And I understand and actually accept that Dr. Ebel's made a choice. As a physician, I've made choices in the type of care that I provide and what areas. You've, in answering Dr. Bullock's question, really give an emphatic no to the practice of obstetrics and anything leading to obstetrics like prenatal care. And I don't know if this is even possible. I'm just asking a question. Would you accept a prohibition to practice any OB care in California?
Can you explain a little bit, like if
you're told that you could not ever practice OB care in California as part of a decision? I don't know if that's even possible. I'm just asking a question. I'm just trying to get a better feel about.
I see. Yes, I would accept that.
Nothing else. Thank you.
Thank you, Dr. Hawkins. Any other board members had a supplemental question? None? Okay, perfect. Thank you so much. All right, that concludes the arguments in this matter. The record is closed. Case is submitted for decision, and we are off the record in this matter. Ms. Lubiano, I'll turn it over to you as to how to proceed. Thank you.
Thank you.
Thank you.
So at this time, we'll be moving to a break. I think we're ahead of schedule. I will defer to council. We still have a 12:30 start. Oh, 1:30. Okay. Okay, so we will be returning for oral argument at 1:30. Thank you.
Is it 1:30? Just checking, Ms. Lubiano. On the agenda, I had it set 12:30, but I know there's been some changes, right, in terms of availability of board members. Perhaps I just want to make sure we're on the same page because I have it as 12:30 for Dr.
Yes, I just checked with staff council here. We'll plan to resume at 1:30.
1:30. Thank you very much. I appreciate it. So I'll be back at 1:30 then. Thank you very much.
Thank you.
All right, we are on the record before the Medical Board of California, Department of Consumer Affairs, State of California. We're here in the matter of the petition for early termination of probation by Kevin George Jamil, MD. This is Physicians and Surgeons Certificate number A113074, Medical Board of California case number 800-2022-087304, and the OAH case number is 2023-110082. Today is November 29, 2023. It's approximately 1:39 p.m. It is the date and time set for oral argument in the notice of hearing for oral argument. We're conducting the oral argument in person and by WebEx video conference. My name is Wim van Rooyen. I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over the oral arguments today. And just to make sure we have a quorum, if I could have each member of the panel identify themselves for the record, please. Starting with you, Dr. Hawkins.
Dr. Randy Hawkins, Vice Chair.
Dr. Michelle Bolat.
Dr. Leung Tsai.
Mr. T.J. Watkins.
All right. Thank you very much, everyone. I do find that we have a quorum of 4 board members present. Now, may I please have appearances by counsel, starting with the Attorney General.
Greg Chambers with the Attorney General's Office, Your Honor.
Good afternoon, Mr. Chambers. And then for the respondent.
Good afternoon, Your Honor, members of the board. Lindsay Johnson for Dr. Kevin Jamil.
Good afternoon to you as well, Ms. Johnson. So we're here because the board issued an order of non-adoption of a proposed decision by an administrative law judge in this matter and set the matter for oral argument before the board's panel A. As set forth in the notice of oral argument, the following process and time limitations will apply. First, the respondent will have 15 minutes of argument, and then the Deputy Attorney General will also get 15 minutes of argument. After that, the respondent will have 5 minutes to make a closing argument, and the Deputy Attorney General will have 5 minutes for a closing argument. These time limits will be strictly enforced. I will try to give counsel a 1-minute warning before your time is up. But again, please make sure and it's ultimately your own responsibility to make sure that you're monitoring your time. The argument shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. Either I or any panel member may ask a party to support the party's oral argument on a matter with a specific citation to the record. At the end of the oral argument by counsel, I will offer the respondent physician an opportunity to address the panel. If the respondent elects to address the panel, I will place the respondent under oath. A court reporter is present to record the proceedings for purposes of creating a record. After oral argument, the board will go into closed session to deliberate. The parties will not receive a decision today, but will be receiving it in the mail sometime in the future. Again, I'll just remind the parties that all arguments must be based on the existing record. No new evidence will be heard. And another reminder that the board has already had the benefit of reading your briefs, but you're certainly welcome to highlight any portions you deem appropriate as part of the argument. With that said, I'm going to turn it over to you, Ms. Johnson, for respondent's opening argument. Your 15 minutes starts now.
Thank you. As this board is aware, respondent was licensed in 2010 and has spent the last 13 years establishing a thriving and professional career. His licensure without monitoring or restriction is supported unwaveringly by those who work with him, those who know him, and those who supervise him. He has been at the same hospital since 2016, and he has risen in the ranks there, moving not only up as a surgeon, but also taking leadership positions. He is double board certified, and throughout his entire career, he has received no patient complaints, superior complaints, employment complaints, and has no criminal history. We originally were before this board for a single isolated incident in 2018, where Dr. Jamil took 3 Vicodin tablets in order to treat pain he was having at the time. Obviously, this was a terrible lapse of judgment, one that he openly and thoroughly has admitted. Following that single incident, he entered into a program agreement with the state of Michigan. He served his time there, and then he signed a stipulated settlement with this board, entering into probation on the basis of an accusation that was for a single cause of action for out-of-state discipline. It has been 5.5 years since Dr. Jamil first started to address this problem through the state of Michigan. It has been 4 years since he has been on probation with this board. And during that time period, Dr. Jamil has tested regularly with no positive results. When he was in Michigan, he was required to meet quarterly with an addictionologist, which went very well. He was required to do regular psychotherapy appointments, which resulted in no concerns. And he was required to do AA meetings, which he fully complied with. Additionally, he has been fully compliant with his California probation with one exception. He has practiced in the state of Michigan instead of the state of California, which is where he was practicing at the time of the underlying incident, where he was practicing at the time of his accusation, and where he has practiced throughout his entire probation. For a year, his California and his Michigan probation overlapped, which allowed his Michigan practice to count for his California practice. However, since the Michigan probation ended and Michigan terminated it with no cause or no concern, Dr. Jamil has been technically considered to be non-practicing in the state of California because of his practice in Michigan. That does not, however, mean that Dr. Jamil has sidestepped any of his other probation requirements. He has continued to test, and his tests have all been negative. He has continued to be supervised at his hospital there, and his supervisor, who testified at his early termination of probation hearing, was glowing in his recommendations, finding Dr. Jamil to be a talented, superior, excellent surgeon. And this was not just a supervisor who occasionally looks at his charts. This was somebody who regularly rounds on Dr. Jamil's patients, who has the ability to interact with him, who sometimes steps into surgery with him to observe him. This is also a supervisor, the chief of the department, who found that Dr. Jamil not only has risen in the ranks of the department, but is universally loved and respected by fellow surgeons, but also by staff, who find him to be exemplary in their process, as well as respected by patients and their family members. Dr. Jamil sits on the head of the tumor board at the hospital, He reviews and analyzes cases to determine whether or not there is something that his department can do to help patients, and he has been universally successful. As we are aware, these proceedings are not designed to punish the public, or to punish a practitioner, I apologize. They are designed to protect the public. And so when determining whether or not a licensee needs to be on probation, we have to analyze, do we have to have eyes on this licensee, or are they safe? Is the public safe if they are being treated? In this case, we have a unique circumstance here where we can look at Michigan already. This board looked at Michigan in order to impose the initial discipline, finding that Dr. Jamil should be placed on probation because Michigan had imposed discipline. We ask that it now once again look at what's happening in Michigan, where Dr. Jamil is practicing and has been practicing for several years without probation there, to see that there has been absolutely no cause for concern. Instead, we see a talented physician who is continuing to thrive in his profession and who is rising in the ranks. For 5.5 years, Dr. Jamil, as mentioned, has been testing and has been reporting to different agencies, whether it be Michigan and now California. And at no point has anyone raised a concern. It would be easy, of course, to ask why we're even here then. Theoretically, probation would end in 10 months, and we're not really shaving that much time off, except we are, and we're asking for something important there because of that. As noted by counsel at the administrative hearing, because Dr. Jamil has not been practicing for 2 years, something that occurred after he submitted his petition, not been practicing in California, of course, that is, then it runs the very real risk of this board bringing a petition to revoke probation for noncompliance. And that, it does not appear, would serve anyone. We know the collateral consequences that stem from a petition to revoke probation, from a surrendered license when there's discipline, or from revocation. And those collateral consequences extend to not just the physician, but to patients, which circles us back to this idea of protecting the public. If one is to surrender their license with discipline pending, it effectively serves as a revocation when reported to the National Practitioner Data Bank, which then extends to all the states in which one holds a license. Dr. Jamil is double board certified, 2 boards that would have an issue with a revoked license. Similarly, we know that California reports revoked license or surrendered license when discipline is imposed to the Department of Health and Human Services, which controls Medi-Cal. And then it can be reported, of course, to the Office of the Inspector General, which controls Medicare. Once one loses their ability to serve those who have insurances where they can no longer participate, especially because the National Practitioner Data Bank is also relied on by private insurances, including Blue Cross, Blue Shield, and Aetna Health, then we run the very real risk of a practitioner being unable to help those with private insurance, those with public insurance, and essentially cripple their practice. As the reality that Dr. Jamil could face if there is license discipline, such as a surrendered license or a revoked license, and that very real reality would pose a danger to the public. If he is unable to practice in Michigan to the extent that he is currently practicing, then we have a real problem. We have a public that's not being protected by removing him from the practice of medicine when there is absolutely no evidence that his current practice poses any danger. No one has raised a concern in 5.5 years of substance use, of substance abuse, of sub-quality medical care, of any sort of danger to the practice of medicine posed by Dr. Jamil. Instead, to the contrary, his reports have been glowing. His letters of reference are equally glowing. His supervisor that testified at the early termination of probation hearing was unequivocal in his opinion that Dr. Jamil is a substantial benefit to the practice of medicine, and that patients, by all accounts, are receiving quality medical care from him. Business and Profession Code Section 2307 allows this board the opportunity to terminate probation early. This is a statute that is imposed for various reasons, but the main one, according to the subsection, seems very clear. When we have a licensee who no longer needs probation, when we are starting to waste board resources on observing and monitoring someone that does not present a danger to the public, then we should terminate that probation early. It's something that we address openly with those who are on probation. We being not only licensing attorneys on both sides of the aisle, but staff and the Office of Administrative Hearings. This idea that there is a mechanism down the road that monitoring allows the board to observe the practitioner as long as necessary. But once that no longer is necessary, then both sides shall part. In outlining that statute, the statute also provides criteria for the board to consider. And when looking at that criteria, it reinforces the idea that Dr. Jamil has achieved what should be obtained here. The offense for which the petitioner was disciplined was Dr. Jamil's sole indication of any sort of wrongdoing. The petitioner's activities during the time the certificate was in good standing. Dr. Jamil, of course, had a lengthy and successful career that has only continued. His activities since that time and his rehabilitative efforts, which are underscored by not only drug tests that were done through urine, but through hair and through blood, going back substantial times, his meeting with an addictionologist regularly, AA meetings, psychotherapy, evaluations, and everything that has been supportive, and his general reputation for truth and professional ability, something that has never been questioned, including by the administrative law judge who initially heard this matter. Ultimately, case law tells us that there is no absolute guarantee that a petitioner will never engage in misconduct again. Petitioner is not required to show perfection. Instead, reformation is a state of mind which may be difficult to establish affirmatively and may not be disclosed by any certain or unmistakable outward signs. Nevertheless, the law favors the regeneration of erring licensees and shall not place unnecessary burdens upon them in proving rehabilitation. No one is saying that unnecessary burdens have been placed on Dr. Jamil, with the sole exception of Dr. Jamil is not able to practice in California. He has a life, he has a family, he's expecting his first child, and all of that is taking place in Michigan. And more importantly, he has patients in Michigan. His current facilities, where he has practiced since 2016, hold 8 different locations, and he is able to serve at all of them. He is serving as the chair of their tumor board, and patients are relying on his expertise there. As a result, Dr. Jamil petitioned for early termination. He waited his 2 years to have his petition heard, and he presented his evidence before the administrative law judge. At that point, Judge Baldwin came to what we believe is the only logical conclusion in this matter, that which is supported by the evidence, supported by the time, supported by the elements laid out by the Business and Profession Code section, and supported by the underlying public policy of this board, in determining that the public is no longer needing any sort of oversight over Dr. Jamil, and the public is adequately protected, the same way that it has been protected through the past, and that is protected because Dr. Jamil is a quality, substantial, supported, excellent, and most importantly, safe physician. And for these reasons, we respectfully request that this board adopt Dr. Baldwin's well-reasoned decision and find that Dr. Jamil's probation should be terminated early, as we see no cause and no justification, nor was any cause or justification raised in the underlying hearing to demonstrate that Dr. Jamil presents any danger to the public, thus requiring the negation or the rejection of this decision. Thank you.
Thank you very much, Ms. Johnson. All right, Mr. Chambers, you have 15 minutes for your opening argument, and that starts now.
Thank you, Your Honor. We certainly don't need that amount of time. The facts are not in dispute here. It's a single solitary issue, and that comes down to compliance. We have terms of probation, which were agreed to in a settlement stipulation that became effective September 20, 2019. We had an issue that was raised just momentarily that there have been no complaints or patient complaints in Michigan. Great, but we're in California. We haven't seen the licensee in California. If one looks at a restrictive interpretation of the 2-year compliance, then the licensees should not get the early termination of probation. If one is going to look at a much more lenient interpretation, then it can be considered. But at this juncture, the burden really relies or really stays with the licensee to meet his burden. And this burden is on him. He brought this petition. So the question is, did he intend when he signed the initial settlement agreement to come to California and complete the terms and conditions of the probation terms? And if not, why was it signed? If so, what happened? So we have a single small issue. We don't have a problem with the facts. The facts were all before you. And this is a very simple question that we had earlier this morning in another matter. And at this point in time, we'll turn it back to the panel and the board. Thank you.
Thank you, Mr. Chambers. Ms. Johnson, if you'd like, you have 5 minutes for a reply argument, and that starts now.
Thank you. I don't think I'll take all 5 minutes, considering that there's not as much to reply to. Turning to the first point, though, that was made on whether or not we have seen the licensee in California. Ultimately, that shouldn't matter. What should matter is, have we seen the licensee practice medicine during the term of probation? And certainly we have. The only thing that would differ if he were in California was he'd be treating California patients. But patients are patients. He has been treating Michigan patients, which are still people with the same health problems that those in California could have. And he has been treating them very well. Simply because that has taken place in a hospital over state lines does not mean that he is not practicing medicine, that he is not supervised while practicing that medicine, that his supervisors are not finding that he's practicing medicine exceptionally, and that his patients are not having good outcomes. We cannot disregard Michigan patients simply because their driver's license has them in a different state. We have seen Dr. Jamil practice medicine, and he has practiced medicine very well. Turning to the second point that was raised on when the stipulation was signed, why sign it? Did he intend to come to California? And if not, why would he have signed it? In essence, is what was just stated. Well, first, it should be noted when Dr. Jamil signed the stipulated settlement, he was on probation in Michigan. And under probation terms and under guidelines, probation in one state counts as probation in another state. California and Michigan's probation overlapped. And at that point, Dr. Jamil was in compliance. And if Michigan's probation had continued, he would have remained in compliance. Simply because Michigan's probation ended and Dr. Jamil was then no longer in compliance with California's term of out-of-state discipline does not preclude Dr. Jamil from not only petitioning for early termination of probation, but also not from being granted early termination of probation. Dr. Jamil should not ask Michigan to extend its probation over him simply so that California can therefore have that probation extended in Michigan. And second, Business and Profession Code 2307, the one that grants early termination of probation, does not require that he be practicing in California. And it does not ask us to consider why a stipulation was signed when it was signed and what the thought process was. That's adding a new requirement on Dr. Jamil. Ultimately, though, the Business and Profession Code section has always been in place. It is something that is regularly relied on and known when one is signing a stipulation on the possibility that early termination of probation can be filed after 2 years of probation. And when Dr. Jamil filed his early termination of probation petition, he was in compliance because of that Michigan-California overlap. The reason we now have the issue that 2 years have passed since he has not been in compliance is due in part to the fact that Dr. Jamil signed and submitted his petition for early termination to this board 2 years ago in December of 2021 and has waited for the last 2 years for this decision to be heard and rendered. It has now put him a little over 4 years in his probationary period, and it's now why we sit here today. Facts and circumstances, of course, have changed, but what has not changed is that we have a very good doctor who demonstrates no danger to the public, who has been released from discipline in Michigan, which is what this board relied on when placing him in discipline in the first place, Michigan's assessment of the situation. And we see no danger to the public. Instead, we simply ask that resources be placed elsewhere and that Dr. Jamil be allowed to continue his practice in Michigan, not impeded by subsequent discipline that could take place in California. Thank you.
Thank you, Ms. Johnson. And Mr. Chambers, you can have 5 minutes for a reply if you wish. Your time starts now.
Thank you, Your Honor. There is no new requirement that has been placed upon the licensee. He signed an agreement that required him to comply with practice in California. 2307 of the Business and Professional Code section is completely separate statute and does not intersect with his compliance with regard to those terms and conditions. With regard to how the board wishes to review his compliance or his practice in Michigan, with regard to his need to practice in California for 2 years, that's going to be an interpretation that's left up for the board at this point in time. Thank you.
Thank you, Mr. Chambers. Ms. Johnson, I wanted to check with you if your client wished to address the panel directly or not. Is that your desire?
It is, and most importantly, he'd like to answer any questions the panel might have of him, because obviously we can all listen to me, but you'd probably rather hear it directly from the source.
Certainly. All right. So, Dr. Jamil, can you still hear me clearly, sir?
Yes, I can, Your Honor.
Wonderful. So first thing I'm going to ask you to do is raise your right hand and I'll swear you in. Do you solemnly state under penalty of perjury that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you so much. You can put your hand down and just state and spell your full name for the record, please.
Kevin Jamil, Jamil, with middle name George.
Thank you very much. Dr. Jamil, at this time, you can make a statement to the panel if you wish, and then I'll ask whether they have any questions for you. Thank you.
Sure. Thank you, Your Honor. I want to thank the medical board first for hearing my case. I apologize that I could not be there in person, both for work-related and personal reasons, but this is very important to me nonetheless. I would like to first say that I respect the duty of the board, and I certainly recognize the significance of the event that led to this disciplinary action. From the beginning, I was aware of the optics of an overdose on Vicodin for a health professional, and I was both embarrassed and ashamed of it. And in order to quell any concerns about substance abuse issues, I voluntarily enrolled in the health professional recovery program in the state of Michigan, and that went along with my probationary terms in Michigan. At the time, when I was offered the discipline conditions in the state of California, as Ms. Johnson had explained, I was in compliance with all the requirements, and I was given two options. One was to have my license essentially revoked at that time, which would have significant ramifications. The other would be to comply with the terms as I was at the time, and then apply for early termination based on my compliance. It's taken a couple years to get to this point, but I'm glad we're here nonetheless, so I can at least present my case. I chose the latter of the two, and I felt that ongoing monitoring with the state of California, which I have done since my terms in Michigan ended, I was hoping that that would quell any concerns of ongoing substance abuse or use issues. As Ms. Johnson explained, I've never tested positive. It's never been a concern. It's never been an issue. So that's all I have.
Thank you very much, Dr. Jamil. All right, I'm going to now turn to the panel members to see if they have questions for you. Dr. Hawkins, do you have any questions for Dr. Jamil?
Yes, yes, thank you. Ms. Lubiano is now returned. My question is
Actually, I'm so sorry, Dr. Hawkins. Let me just address that. I saw you return, Ms. Lubiano, but am I incorrect in that you did not hear all of the arguments in this matter and when you joined?
That's correct.
All right. So I'm sorry. I just wanted to make clear. That's why I didn't turn to you first, because I'm assuming you didn't participate in all of it. So for this matter, you will not be participating in the decision making. So that's why I turned to Dr. Hawkins first. Thank you so much.
Thank you.
Thank you very much. My question is for Dr. Jamil and any of the two lawyers present. At any time during the 2 years where, quote, there's overlap of probation. Was Dr. Jamil ever monitored by any part of the California Medical Board probation department? Did they see reports? Did they get test results? Was he actually really monitored by the state of California?
I'll jump in since doesn't appear anyone else's. He was submitting regular reports to California. California, although they are relying on Michigan, there's still quarterly reports that are being turned in during the probationary period.
That's my only question. Thank you.
Thank you, Dr. Hawkins. Dr. Bolat, do you have any questions for the physician?
Not at this time, Your Honor.
Thank you so much. And Dr. Tsai, do you have any questions?
No, I just wanted to, one of the points that was harped on the stipulated decision, and and of course, counsel answered why there was overlap. So my question's been answered.
Thank you, Dr. Tsai. And then Mr. Watkins, do you have any questions for Dr. Jamil?
Yes, I've got a few questions.
Certainly, go ahead.
So my first question, good afternoon, Dr. Jamil. My first question, I'm concerned, these are more concerns and questions. California made its decision to stipulate on this matter based on the facts found by Michigan. And in your testimony at your at hearing, you actually contested some of the pertinent facts, and specifically, I will raise what you were contesting. You point to that you only took 3 Vicodins from a family member. Is that correct?
Yes, that is correct.
And upon Michigan's investigation on the automated prescription system, they never found a prescription on that family member in their database. Is that also correct?
That is correct.
Can
I, if I may, sir, the reason that was never found is because the MAPS program in the state of Michigan, and maybe nationally as far as I know, but it only went back, I believe, 5 or 10 years. And those Vicodin pills were from well before that. As foolish as that sounds that I took old Vicodin pills, they predated the MAP system where they would even be able to find those.
Okay. And also then you contested that there was 2 overdoses at hearing when the Michigan investigation found that Narcan was administered once on the March 8, 2018, and then 7.5 hours later, Narcan was again administered. And then you were, escorted to the hospital of your choice. Can you explain that to me or to the board?
Sure. At the time of my hearing, it was brought up that there were 2 separate overdose incidents where this was actually the one incident, and that's what I had contested, is that Narcan was administered once, and then the effects of it wore off, and then it was administered a second time. But that's because the EMS was called again. The first time I refused to go to the hospital. The second time I agreed. But this was not 2 separate incidents where I had taken Vicodin, and that's what it was made to sound like in the hearing, and that's why I contested it. But I don't contest that Narcan was administered twice in that same morning.
And the final thing was, you claim this to be an isolated incident, and yet the Michigan, based on their findings at St. Joseph Hospital, when they reviewed the records, it indicated that you had an history of occasional cocaine usage. Is that correct?
At the time, I admitted that I had used cocaine in the past, correct.
Okay, thank you. So my next question was, when you entered the stipulation in California, there was 22 stipulations. And I just want to go through a few clarification points because I'm hearing everybody, and it seems like the only probation that counted was that probation that was in Michigan. And this is the reason why I say that. Right now, here's a question. Are you doing any biological fluid testing?
Yes, the answer to that question is I have been testing throughout this process. When Michigan ended testing, I have been testing with California through Vault Health, and that includes occasional blood alcohol tests and urine tests.
So you have been, and that from first source was submitted to California?
That's correct.
Or was it submitted only in a declaration? Or was the actual exhibits submitted to California?
I'm not sure I understand. I'm not sure I can answer that. I don't know.
In California, when we do the fluid testing, the board would usually get a direct piece of paper that confirms that you've tested. They called you randomly and you've tested and everything checks out. When you did that in Michigan, such a form should have also been produced. Was such forms ever submitted to California?
As far as I know, my case manager for the state of California, my probation manager, was in regular contact with the HPRP case manager, and they would submit those forms over.
Okay, and so then we also moved over to the substance abuse support group, and you mentioned that you did like 12 AA meetings a month.
Yes, sir.
Is that correct?
Yes, sir.
Again, I was looking for the exhibits that pointed to those AA meetings as in compliance in California. In California, we also require that those exhibits be made to the board. When we review these cases, those are some of the documents that we look at as well. And you've had a worksite monitor, and that worksite monitor testified at hearing, so that checks out. Here's the other condition. Patient disclosure forms about informing your Michigan patients about discipline in Michigan would not be relevant if that's not a condition in Michigan, right? But it becomes a condition in California. And so when you ended the Michigan probation, these conditions were not met in California because you weren't here.
Right.
Do you see what I'm pointing to?
Yes.
And here's another question that it is mentioned a lot that you are in compliance except for this one thing. You were sent I just want to find this note now. Were you ever sent a non-compliance notice?
Yes.
Right, and that non-compliance notice was for that you're not practicing in California. And it was also to remind you about submitting quarterly reports, which was late on more than 2-3 occasions to bring you in compliance.
Right. Those quarterly reports I was sending by U.S. mail, and there were many times, especially during the COVID, where U.S. mail was quite slow. So I believe she would have received those letters within a few days of the required date. And we're not allowed to send them in early because we can't fill them in until the quarter ends. And so that's why there were a few of those.
And my final two questions pertains to, licenses that you've had in Pennsylvania and in New York, if I'm correct.
Yes,
And the one in Pennsylvania, the one in New York, you just never renewed it. Is that correct?
correct.
I've looked at it on A92 where the New York Medical Board presented its stipulation. And next to California, it was equally as tough to do that stipulation. And why was the decision to let go of the New York license and not the California license, since you have not practiced in California for the last 4.5 years or 4 years?
Right. I would have surrendered my license or let that license go in the state of California if it didn't mean that it would be a revocation of my license. The state of New York agreed to make it not a revocation of my license, but rather a surrendering of my license, with the stipulation that if I ever agreed to, or if I ever decided that I was going to practice in the state of New York, that we would reopen the case and reevaluate any probationary terms.
My final question, if you were in California, we would have monitored you in a very specific way. A lot of accommodations were made while you were in Michigan with regard to the monitoring, and everybody points to the fact that we are only monitoring the substantive aspect of the substance use issue. But if it was just that stipulation, this would all be okay. But there were a host of other conditions as well that I personally looked at and questioned whether there was compliance. But I want to thank you for your time and thank you for answering all my questions. I appreciate it.
Thank you. As far as, am I allowed to speak?
Well, I wasn't sure if there was a question in that last, more than a statement, but I'm going to give you an opportunity to respond to that if you wish. Yes.
Oh, sure. No, I was just going to say that I'm not sure how familiar the board is with the terms of probation in Michigan, but there were several other stipulations other than fluid testing. Some of them were mentioned, which were the 12 AA meetings a month, which I have documented records of that were submitted through my probation manager, but also monthly meeting with therapists, quarterly meetings with addictionologists, as well as group sessions once a week. These were caduceus meetings, and I was in compliance with all of those as well. So it was more than just body fluid testing as well.
I just want to mention that I was looking, I requested this documentation and exhibits, and California did not have these exhibits or documentation.
Your Honor, if I may jump in real fast.
Yes, Ms. Johnson, go ahead.
Thank you. We would simply point to the fact that Dr. Jamil has submitted everything that's been required by his California probation monitor, and California enforcement from the medical board has found Dr. Jamil to be compliant with probation. So any questions or concerns raised now on whether or not he's compliant outside of the one term which they have noted, which is the non-practice of medicine, is contradicted by the board's own documents finding him to be compliant. So we would have a serious concern if there is now a question or concern raised that Dr. Jamil has been allegedly not compliant with other terms when California has routinely signed off on that. They've accepted the reports. They have asked Dr. Jamil or told Dr. Jamil how to submit his compliance, and they have accepted that in response to those submissions. So the idea that we would now backtrack from what California has asked of him and has found that he has successfully done raises a pretty serious concern on this side. Additionally, going back to the first question that was raised, I just want to point out that Dr. Jamil's stipulated settlement includes soft admissions, not hard admissions. So the idea that he agreed to everything in the accusation under the stipulation is not in fact true. It was a soft admission and he agrees to the underlying substance. But to look back at the Michigan discipline and call him out on each one to say whether or not he agreed with that in his hearing is contrary to the documents itself, and therefore would raise a concern if that became an issue as well. Thank you.
Thank you, Ms. Johnson. Yeah, the board will apply the law as it stands, regardless of individual member questions. The board will apply the correct law and its disciplinary guidelines and applicable law in deciding the case. That's as much as I can guarantee. So with that said, any other questions by other board members before we close the record? I don't see any. Thank you very much. At this time, the record is
Sorry,
closed.
Your Honor,
I'm sorry.
I have one last question.
Oh, sorry, Dr. Sai. I'm sorry, I didn't
Yes.
see you. Please go
No,
ahead.
you're waving. It's okay. Question to Dr. Jamil. Do you intend to ever practice in California?
Dr. Sai, I love the state of California. I can tell you, in all honesty, my 5 years in residency at UCLA were some of the best 5 years of my life. But because of family, extended family, my wife's family, we're all situated here in the state of Michigan. I don't have any immediate or long-term plans to return to practice in the state of California.
Thank you.
Any other board member? I'm sorry, I don't want to, I apologize again, Dr. Tsai, I didn't see you. My view is very limited, depends on where the camera is pointed. So just speak up if any board member wants to ask a question. All right, I'm not hearing any additional ones. And so that concludes the arguments in this matter. The record is closed. The case is submitted for decision and we are off the record in this matter. And I will turn it back over to you, Ms. Lubiano, as to how to proceed next on the agenda. Thank you.
Thank you, Judge. Thank you. All right. Now we're moving to item number 8. This is oral argument following Superior Court remand for Dr. Leung.
All right, we are on the record before the Medical Board of California, Department of Consumer Affairs, State of California. We're here in the matter of the first amended accusation against Martin Chan-Hoi Leung, MD. This is Physicians and Surgeon Certificate number G39648, Medical Board of California case number 800-2018-040-046. And the OAH case number is 2023-110-083. Today is November 29, 2023. It's approximately 2:33 p.m. This is the date and time set for oral argument in the notice of hearing for oral argument. We're conducting the oral argument in person and by WebEx video conference. My name is Wim van Rooyen. I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over the oral argument. To ensure that we have a quorum, I just would ask each member of the panel to identify themselves for the record, starting with Ms. Lubiano.
Lori Rose Lubiano, present.
Dr. Randy Hawkins.
Michelle Bolot, present.
Feeling Sai present.
Ezric Tidze Watkins.
All right, thank you very much, everyone. We do have a quorum present for purposes of hearing arguments. And then let me take the appearances of counsel, starting with the Attorney General, please.
Good afternoon. Michaela Mingardi for the Office of Attorney General.
Good afternoon. Thank you so much for being here. And then on behalf of the respondent.
Yes, Jeff Kravitz on behalf of Dr. Leung.
All right. Good afternoon. Thank you and welcome. So we're here because there has been a remand in this matter by the Superior Court of Sacramento County. And this matter has been set for oral argument before the board's panel A after the remand. So the following process and time limitations will apply as was set forth in the notice of oral argument. The respondent will have 15 minutes for an opening argument. After that, the Deputy Attorney General will have 15 minutes for an opening argument. And then the respondent will have 5 minutes for closing argument, followed by the Deputy Attorney General's 5 minutes for closing arguments. These time limits will be strictly enforced. I will try and give everyone a 1-minute warning before your time is up each time. But again, I'll just ask counsel that it's ultimately your responsibility to monitor your time, but I'll try and give you a courtesy warning. The arguments shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. Either I or any panel member may ask a party to support the party's oral argument on a matter with a specific citation to the record. At the end of the oral argument by counsel, I will offer the respondent physician an opportunity to address the panel. If the respondent does elect to address the panel, I will place the respondent under oath. There's a court reporter present to record the proceedings and for purposes of creating a record. After oral argument, the board will go into closed session to deliberate. The parties will not receive a decision today, but will be receiving it in the mail at some point in the future. And I'll just remind the parties that the board has had the benefit of reviewing the package and briefing. So, but you're certainly welcome to highlight any portions you deem appropriate. With that said, I will turn it over to you, Mr. Kravitz, to present respondent's opening argument, and your 15 minutes starts now.
Need to unmute yourself.
I think I was muted accidentally for a second there. Okay, thank you. This case has gone on for quite a long time. And originally, there were 6 allegations brought against Dr. Leung. One concerned negligent treatment of a patient who had received a prescription for opioids. And the other major allegation concerned an allegation of sexual abuse of a patient. And then there were 2 allegations concerning his failure to appear at the investigation conferences for both of those matters. So that's where we started. Where we are now is that following a hearing in which in the course of the hearing, part of the first allegation was dismissed. Then at the end of the hearing, the court dismissed the allegations concerning the sexual abuse, which was adopted by the board. So the position of the medical board right now is that there was not sufficient evidence to sustain that allegation. And that's very important to understand, and we'll go to my further comments. And then I have read now, following the writ, we challenged certain presumptions that the medical board had made concerning the necessity of doing cures reports. Reading the brief of the Attorney General's office on this, who represents the board, it appears that they're saying for the first cause for discipline, there's no need to make a final finding on that. The court left it up to the board whether it wanted to make a final finding on it, and that you could proceed completely on the allegation of failure to maintain proper records. That's really what it is, that some of the records were difficult to read and so forth, which, by the way, during the course of the hearing, Dr. Leung admitted his handwriting could have been better. It's important to note that there were huge amounts of documents, both handwritten and typed by a computer system, and they were sufficient so that the board's expert could determine that the prescription of opioids was correct. He was able to review them and find that out. So whatever he couldn't find out was not substantial. But I would like to take a step back here before I make a purely legal argument. And this is a medical board. I'm not familiar with who exactly is on the board, but I'm assuming some of you are medical professionals. So here's the situation. A patient comes to you, and at first your belief is that they have 6 conditions, serious ones, and you decide what treatment is needed. Then after a long course of discussion, you decide that, oh, that's not true. We were in error. You, being an intelligent health professional, are very happy. What has happened here is that you had a thought about something and you gained new information through the process of your examination of the person, and you found out that, hey, what I thought was correct isn't correct, but I'm a professional. So I'm very happy to find out that this person does not have those conditions. So in this case, following the original hearing, there was a determination to put Dr. Leung on probation. Now we've gone through the writ process and we found out that some of the things the medical board thought were true, were correct understandings, are not true. So if you were a doctor and you found out new information about the condition of your patient, you would think, I should alter the treatment because you've now received new information. So here you have new information. Your understanding of Dr. Leung should be different now than it was at the time the accusation was filed, because it's turned out that not all those allegations in the accusation were sustained. As a health professional, you would then say to yourself, well, what is the age of the person in question? What is their total medical history? Who are they? What is the way to best treat them? What should we do now? You would not say, well, you know, before I got the new information, when I first filed the accusation, I thought this, and I'm going to stick to that thought. That wouldn't make sense. You would think, what is this in this situation in question? How do we deal with it now? Who is Dr. Martin Leung? He's a doctor who has served for over 40 years as a health professional and served his community. There has never been any sustained allegation of him harming any patient. The patient in question here had never complained. And according to your expert, the patient received the correct treatment. There is no dispute. No one has ever said the patient was not properly treated. No one. So you're saying in the course of a 40-year career in which Dr. Leung may have treated countless, thousands would be logical to believe, patients, no one has ever sustained an allegation of any malpractice on his behalf. But we're going to put him on probation. That makes absolutely no sense. None. There can be no logical reason to think that. The board has no punitive desire. It has no goal to punish. Its only desire is to protect the public. The public is protected if it understands that the medical board is capable, as all professionals should be, of distinguishing between those practitioners who need discipline, who need to be put on probation, and those who do not. Dr. Martin Leung does not need to be put on probation. It is my belief that the best course of action here would be to dismiss the case in its entirety. There's absolutely no need whatsoever to discipline Dr. Leung. As a matter of fact, he currently does not practice, but he is a person of dignity. He is a human being who was, according to the Medical Board of California, according to this board, he was accused of something for which there was insufficient evidence to sustain the allegation. That is the determination of this board. Now, I want you now to imagine you have been accused of something, of sexual abuse of a patient, and you didn't do it. And you come before your peers and you say, hey, this didn't happen. What would you think your peers should do? What should they do? Should they then punish you more for it? It didn't happen. He's practiced for 40 years. He was humiliated by the allegation. The other allegations here, really, honestly, there are practitioners who ran pill mills. There are people who distributed opioids all over the place. This isn't Dr. Leung. You have no evidence of it. It's not even actually accused. There is no allegation that the prescription was unwarranted. So the allegation is that a man in his 70s, whose first language wasn't even English, who used handwritten notes for much of his practice before there was computer notation, and who said, you know, it could be better. Some of his writing was difficult for people to interpret. And that one thing is equal for putting somebody on probation. But then it gets back to the medical analogy. You would put on probation a doctor who may have incorrectly prescribed medications, opioids. I know this is a fact because I do this all the time. And you would put that doctor on probation. So you would say there's no distinction. We give the exact same treatment to each person to protect the public. That, of course, harms the public. The failure to distinguish between those who need to be put on probation and those who don't harms the public. There can be no benefit to anyone in the public from putting Dr. Leung on probation. It discredits the medical board from doing so. That would be the opinion of the average person. Just like it would be if you were to see a doctor and you say, well, doctor, I heard you were prescribing a surgery for this patient, but didn't you later find out when you took further x-rays that the patient didn't have that condition? I found that out. But, you know, I felt like going forward with the thing I thought before. Why should new facts bother me? Why should the fact that a case was adjudicated in court in which a position was taken concerning the cures reports and so forth, in which it was found the position of the board is not the correct interpretation of the rules? Why? It doesn't make sense. The definition of a professional, the definition of intelligence is people who realize we may have been in error. That's how you know people are smart. When people say that's what happens. All the time when I practice law, if I suddenly discover I was wrong, I'm happy. Because my entire training and practice has been to discover things, to learn things. So in the course of this case, there was an opinion about Dr. Leung. I understand that. An investigator made an investigation. They heard some information. They came up with a thought. Now we've gone through the process. Courts have ruled on it. It turns out some of the things we thought were wrong. As I say, the most logical, the most just, the fairest, the thing that every one of you would want to happen to you if you were in this situation would be to dismiss this allegation. If that is not what you decide to do, then you can give Dr. Leung a letter of public approval, and there should be no cost whatsoever given against him. He spent quite a great deal of money on this. By the way, on the one issue concerning his not going to the meetings, we were not his lawyers then. They didn't properly advise him, and they didn't properly inform the investigators the reasons he might not attend the meeting. So we have to look at this. Is the public going to be protected by putting a man who is retired? He is. He's in Hong Kong right now on vacation. Travels half the year. Who's worked for 40 years, well known in his community as a great man, a man beloved in his community. Are we going to say that the just thing to do, the fair thing, and as I stated, the medically logical thing to do, would be to put him on probation? Or does the medical board, which I believe they do, have the capacity of reviewing facts and coming to a conclusion that actually this case should be dismissed, or at the most, a letter of approval be put on his file? The only problem I have with the letter of approval being put on his file, in general, I wish this case had been settled, which we proposed many times, is that the letter of public approval would not dismiss the accusation from being part of the public record. And therefore, the unfounded allegation by your admission of this board, which you have voted on, which is that there is not sufficient evidence to sustain the allegation concerning sexual abuse, would remain in the public record. And I think where we have the ability to erase an erroneous public statement, we should do so. We should take the next step and say, hey, let's not put that in the public record. If that could be done some other way, maybe it could be. Maybe you could amend the accusation and then issue a letter of public approval, only listing those things, the public approval, which would be for the difficult to read records. That would make sense. But I've put it to you, and I'm very certain of this. If the case had begun and the only allegation sustained and the only allegation filed was difficult to read records of a doctor who's been practicing for 40 years, who said it could be better, and he had failed to show up at a meeting and so forth investigating it, no one would have put him on probation. It's not even possible. It would have absolutely been a case that would have been resolved as a letter of public approval. And that is all that should happen here, because that is fair and that is just. And that is what every one of you would want if you were in the same circumstances as Dr. Leung. Thank you.
Thank you, Mr. Kravitz. All right, now, Ms. Mingardi, you have 15 minutes as well for an opening argument, and that time starts now.
Thank you, Your Honor, and good afternoon, board members. I'd like, first of all, to direct the board members back to the papers that you read. I do think, with all due respect to Mr. Kravitz, there were a number of inaccuracies and misstatements made. So I want to make sure that we're very clear of what actually happened in this case. The respondent was found to have committed several causes of action, including 2 counts of unprofessional conduct. Those causes of action were sustained by the Superior Court of California, and those causes remain, and they are here back before the board in their entirety, having already been considered and affirmed by Judge Arguelles. In addition to those 2 counts of unprofessional conduct that were sustained, the court also sustained the count of poor and illegible medical records. So we're talking about 3 causes of action that were sustained and upheld that are remanded back to the board, not for those to be reconsidered, but the court inquired and said if the board would like to reconsider after eliminating 2 of the factors for gross negligence, you can look back at gross negligence or not and decide if you have enough to sustain that cause of action in addition to the 3 causes of action that were already sustained, to see if you wanted to revisit that count. And it's our position before the board, there is no reason or no need to go back into the weeds of the factors for that 4th count of unprofessional conduct, because it's not necessary. The original discipline that was carefully put forth for the respondent, carefully considered, actually did not include any requirement of a prescribing course, a controlled substance log. Nothing of that was in the initial discipline imposed. We don't need to revisit that. The probation matter and the term. I'm sorry, I lost you there for a
We lost you
second.
there for just a second, Ms. Mangardi. If you can just retrace your last 2 sentences, that'd be great. Thank you.
Absolutely, apologize for the connection there. Going back to the original discipline imposed by the ALJ, it was a 5-year term of probation, a professionalism program, which is the ethics course, the medical record keeping course, and the standard terms and conditions. Very reasonable, and these same terms and conditions are supported by the 3 remaining causes of action that were upheld by the Superior Court of California. The note that the court did give, as detailed in our papers, according to the Zuckerman case, because the initial decision put forth the full cost and fees of the $24,357, a reduction is indeed warranted at this point. And we propose that cutting those fees in half to $12,178.75 seems to be a reasonable reduction, a 50% reduction in light of the Zuckerman ruling and the court's ruling to date in this matter on the writ. The other issue that I wanted to highlight that was, of course, glossed over by the respondent is to focus back in on the unprofessional conduct counts for 2234G. 2234G was enacted by the legislature because our system found do not just fail to appear. This isn't a situation, as stated by Mr. Kravitz, where the respondent failed to appear for his subject interview. Not at all. The respondent refused to schedule a subject interview, refused to appear for a subject interview, and in essence obstructed the investigation of the allegations in this case, both for prescribing and for sexual misconduct. It's that obstruction that the legislature has found is contrary to public interest, contrary to public safety, and in and of itself constitutes a cause of unprofessional conduct. It's that obstruction here that actually created substantial delay, substantial additional resources, and we're here to this point because the respondent refused to cooperate with the investigation. That's why we need this section, and that's why licensees need to be part of the process when they are under investigation, so that we can uncover the facts, so that we can evaluate them properly, that medical experts can evaluate them with the full information. Obstructing the investigative process of the Medical Board of California is a serious matter. The legislature found it to be serious and enacted this section to require a subject licensee who is under investigation must participate in their subject interview. If they refuse, it's an act of it's an act of unprofessional conduct. These causes of action, along with medical record keeping, and that is not in dispute. The respondent admitted his medical records were in part illegible. Both experts found and testified that the medical records were illegible, subpar. And so that count is not in dispute at all. Taking all three causes of action that were sustained combined, the probation discipline is not only reasonable, but necessary, and necessary under the guidelines. This is not a public reprimand case. This is a probation case. The professionalism program with the ethics course is, I think, should be and is required under the disciplinary guidelines. Certainly a medical record keeping course is required, and the rest of the standard terms and conditions are not onerous. I think with that, I would be willing to submit it and then wait for rebuttal for any additional questions. Thank you.
Thank you, Ms. Mingardi. Mr. Kravitz, you have 5 minutes of reply argument, and that starts now. Thank you.
Certainly. Well, as has just been explained and stated, is that the comment here from the medical board attorney to the board is that the probation should be put in place for 3 causes of discipline, which we stated what those 3 causes of discipline were. I don't know what I didn't state. Even if there is no revisiting of the first cause for discipline, which means it would be the first cause for discipline would be dismissed then, and so forth. So therefore, my original comment is a correct statement of fact, which is that the proposal is that the discipline would be exactly the same, even though one of the other causes for discipline is dismissed. This can only mean that there's sort of a one-size-fits-all type of discipline. There was no discussion of the issue, the quintessential issue of whether or not the actions are designed to protect the public. And the idea of protecting the public is to protect the public from dishonest and incompetent physicians. It's not designed, and there's many case laws on it, but again, we can just use common sense. It is not designed to punish at all. It's designed to improve the practice of medicine. Again, the practitioner in question here is 72 years old, and someone is proposing that they be placed on 5 years of probation, because in one case, you only had one case before you, so you can only use that evidence. Some of the records were illegible, and he did not attend 2 meetings of investigation. One of the investigation meetings was for an issue that was later determined there wasn't enough evidence to go forward. So we have that. And to say that you would get new information, to say that there would be less sustained allegations, but you'd do the same discipline, flies in the face of logic of law, and, as I said before, absolutely flies in the face of all logic of medicine, which would be that you treat the patient based on the totality of the information that you have, and that if a previous determination is found to no longer be needed, you discard that one and you go forward with as it is before you. So as it is before you, you have a situation in which these are the allegations. The public will be perfectly well protected if the allegations are dismissed. As I've stated, if you wish to, you could issue him a letter of public reprimand. I would hope there'd be some way of amending the accusation so the old accusation wouldn't be in public if you were to do that, because that would be just and fair. To simply rubber stamp your prior discipline, of course, who knows, could lead to a whole nother round of litigation. I don't know. But aside from that, it just doesn't make any sense. It makes no sense. It's illogical. When something new has happened, when you have new information, the definition of a professional is to use the new information to say, hey, maybe we were wrong in what we thought before. We're going to actually look at the evidence again now, and we're going to determine what makes sense for this person take the totality of factors, the length of time, the fact that there was no patient harm, the correct medication was given, and do that over an allegation that some of the handwriting of a 72-year-old man was not easy for people to read at some point. That's what you're weighing here. The board's goal is not to discipline. The board's goal is to protect the public. The public is best protected by allowing Dr. Leung to maintain his dignity, because it sends a signal to all of the other practitioners out there, especially the ones who are over the age of 60 or 65 and so forth, that they are not going to be faced with allegations at the twilight of their career which completely discredit their excellent work, which is what happened here. An allegation that this board has agreed there was insufficient evidence to sustain was made against him. A heinous allegation of his reputation was made. Let's restore his reputation, and let's restore his faith and the faith of the public in the rationality of the medical board. Thank you.
Thank you, Mr. Kravitz. All right, and I'll turn it back to you, Ms. Mingardi. If you have any reply argument, you have 5 minutes as well. Thank you. That starts now.
I do. Thank you, Your Honor. I would ask that the board members not be deterred or swayed in any way by the implied threat of potential future litigation. Obviously, that's what the Office of the Attorney General is here for, and we're not deterred by any potential future litigation in any case, and certainly not in this matter. As to Mr. Kravitz's other points, we certainly believe that the discipline imposed in this case was reasonable, because the ALJ was actually quite reasonable in her decision and in the original decision meriting this discipline here. If the board would like to revisit it and decide, okay, maybe we'll come down to 4 years probation, possibly 3, that's certainly within the board's discretion. And that's something that the board certainly can do, I think, within the disciplinary guidelines. But that is not to say in any way that this is a case that should be dismissed after the Superior Court of California has sustained 3 causes of action, including the 2 causes of unprofessional conduct, as we've discussed. It would be also inappropriate to do a public reprimand in a case in this matter. When we talk about protecting the public, when we talk about the ethics and the professionalism of our physicians, certainly being held to have committed 2 acts of unprofessional conduct that are involving obstruction of an investigation should be considered in that analysis. And certainly a probationary term with the requirement of the professionalism course is merited to have both the rehabilitation that Dr. Leung has shown that he needs, and also to ensure the public is protected as to all regards in this matter. And with that, I would submit it. Thank you.
Thank you, Ms. Mingardi. Mr. Kravitz, I just wanted to check with you. I think you said earlier on that you did not intend to have Dr. Leung make a statement to the panel.
I made that statement without him having input in it. So if he's here, you can ask him.
All right, let me see, Dr. Leung. I know you have been promoted up, I think, to a panelist, I believe. If you can unmute yourself and just let me know whether you'd like to make a statement to the panel.
Could you hear me?
Dr. Leung, before you do that, though, if that's going to be your choice, I need to just swear you in as a witness first, okay? So let me ask you first, you would like to make a statement?
Yes.
All right, perfect. If you could raise your right hand, I'll swear you in, okay? Do you solemnly state, under penalty of perjury, that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you very much. Could you please state and spell your name for the record?
Martin Leung, MD, MARTIN, LEUNG, MD.
Thank you very much, Dr. Leung. And just a reminder, just to speak up as much as you can, because you're a little bit soft-spoken. I want to make sure that everyone can hear you clearly. So with that said, this is your opportunity to address the panel. Thank you.
Thank you very much for letting me speak, Your Honor. First of all, I did not go to the meeting is because the recommendation of my previous lawyer telling me that they are charging you criminally, and I don't want you to say the wrong thing and incriminate and get you a sentence. So that's why I did not go, because the accusation saying that I am criminally accused. That's why the meeting, the lawyer recommend that I do not attend for begging the Fifth Amendment. That's number one. Number two, I on my handwriting has been done for over 43 years, and because of that, all the appointment is backed up by a computer printout, which is also submitted to court. So it's not just my handwriting. My handwriting is submitted with a computer printout on every single visit, on all the patients. So my note is only for myself, and it's supplemented by a legible printout. And the board also have a copy of the printout completely. So to say that my handwriting is wrong, it's not correct. It is already explained in my printout note. So this handwriting problem should not even be discussed. My attorney, when they I raised the question on the first hearing with Paul, but he said, well, give him a carrot, let them use that as a recommendation. I said, the record is not incorrect, it's already printed out. And he said, well, let's let them go on. I mentioned, but I didn't get a chance to speak up. So I'm glad you let me have this chance. Thank you very much.
Thank you, Dr. Leung. All right, now I'm going to turn to the panel members to see if they have any questions for Dr. Leung or counsel. I'm going to start with you, Ms. Lubiano. Do you have any questions?
No questions at this time.
Thank you. Dr. Hawkins.
Yes, thank you. I'd just like to get clarity. Did Dr. Leung decline to participate in the process required for his evaluation? I mean, I'm confused. I'm not sure if he said he was explaining that in the beginning or not. I just need some clarity about, did he actually decline to actually schedule and participate in the investigation that was required?
Yes.
I can answer. Yes, he did. I believe his lawyer sent a letter that he was not going to be participating. I think it was part of the record, but yeah, he did not show up.
And what was the reason for that, please?
Well, as he stated.
If I may, I'm sorry. Excuse me, Mr. Kravitz. If I may, Dr. Hawkins, he was asked repeatedly by the investigator to appear for the subject interview into the accusations that were made. His attorney responded in writing that he refused to sit for the interview. He refused to participate. No reason was given, no explanation. And I believe that's the record that we have to look at.
That's correct.
No other questions. No other questions. Thank you.
Thank you, Dr. Hawkins. Dr. Bolat, any questions?
I have no questions, Your Honor.
All right. Thank you so much, Dr. Bolat. Dr. Tsai, any questions?
No questions.
All right. And what about you, Mr. Watkins? Any questions?
I have no questions.
All right. Thank you so much. Any other board member change their mind before we close the record? I don't see any hands up or anyone speaking out. So thank you very much, everyone, for your arguments. At this time, the arguments are concluded. The record is closed. Matter is submitted for decision, and we are off the record in this matter. The panel will deliberate in closed session at a later juncture. I will turn it over to you, Ms. Lubiano, as to how to proceed next on the agenda.
Thank you, Your Honor. Thank you, Board.
Thank you. Moving along to item number 9, we'll now go to closed session for, we're going to go take, okay. Correction, we're going to move back to item number 6 for Dr. Gentile.
All right, we are on the record before the Medical Board of California, Department of Consumer Affairs, State of California. We're here in the matter of the petition for early termination of probation by Eva M. Gentile, MD. This is Physicians and Surgeons Certificate number A42926. The case number for the Medical Board of California is 800-2021-083. 181, and the OAH case number is 2023-110078. Today is November 29, 2023. It's approximately 3:48 p.m. This is the date and time set for oral argument and the notice of hearing for oral argument. We are conducting the oral argument in person and by WebEx video conference. My name is Wim van Rooyen. I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over the oral argument today. To ensure that we have a quorum, could I have each of the panel members identify themselves for the record, please, starting with Ms. Lubiano?
Lori Rose Lubiano.
Randy Hawkins.
Michelle Bolat.
Leung Sai.
Ezric T.J. Watkins.
Thank you very much. I do find that there's a quorum to conduct oral argument in this matter. And now please appearances by counsel, starting with the Deputy Attorney General.
Good afternoon, Your Honor. Jason An, Deputy Attorney General. Last name is A-H-N as in now.
Thank you. Good afternoon, Mr. An. Welcome. And then we have, I know we've been informally introduced off the record, but Dr. Gentile, if you can just state your name and appearance for the record.
Eva Marie Gentile.
All right. Good afternoon, Dr. Gentile. Thank you for being here. So we're here because the board issued an order of non-adoption of a proposed decision by an administrative law judge in this matter and set the matter for oral argument before the board's panel A. I guess before we proceed, I just want to make sure I asked you this off the record, Dr. Gentile, but you are representing yourself in this matter. You do not have counsel representing you, correct?
Correct.
All right. And you understand that you do have the right to be represented by counsel, but at your own expense. So in other words, you have the right to either represent yourself as you've chosen to do, or to retain an attorney at your own expense to represent you. And do you understand that?
Yes.
And it's still your desire to proceed representing yourself today?
Yes.
Thank you very much. All right. I'm going to explain the process by which we will conduct the oral argument. And if there's any question, let me know. So we follow fairly strict time limitations for the oral argument as was set forth in the notice of oral argument. You will go first, Dr. Gentile. You will have 15 minutes to make an opening argument, any arguments you wish to make to the board. Then the Deputy Attorney General will have 15 minutes to make his opening argument. And then after that, you will have another 5 minutes for a closing argument. So any additional arguments or anything in response to the Deputy Attorney General at that time. And then the Deputy Attorney General at the end will have 5 minutes for his closing arguments. As I said, these time limits are strictly enforced, so I will be keeping time. I will try and give both parties a warning of 1 minute before your time is up. But again, it's each of your own responsibility to make sure that you're keeping an eye on the clock. So my reminder is only a courtesy. The arguments shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard by the board today. The panel members may ask questions of the parties to clarify their arguments, but may not ask questions that would elicit any new evidence. Either I or any panel member may ask a party to support that party's oral argument on a matter with a specific citation to the record. At the end of the oral argument, I will offer you, Dr. Gentile, an opportunity to testify as well, as an opportunity to address the panel. In other words, Beyond the arguments that you offered, you also have an opportunity to address the panel personally under oath. If you do that, then I will place you under oath prior to you doing that. There is a court reporter here that is present to record the proceedings so that there's a record of the arguments today. After the oral argument, the board will go into a closed session to deliberate. So the parties will not receive a decision today, but you will be receiving it in the mail at some point in the future. You can understand that the board has already had the benefit of reading the packet and your briefs, so you don't need to repeat necessarily everything that's in there, but you can certainly highlight or emphasize any portions you deem appropriate. Dr. Gentile, do you have any questions about those instructions before we proceed with the argument?
No, thank you.
All right, thank you very much. So then I will turn to you first. You will have 15 minutes for your opening argument, and that time starts now. Thank you.
My name is Eva Marie Gentile. Thank you for the opportunity to address this panel, and thank you so much to be able to do this remotely. And I know this was not easy this time. My intent is to clarify for this panel and the board my justification for requesting an early termination. I would like to give you a brief history of my background. I am 70 years young and have been a board-certified family physician since 1985, just over 38 years. I was born in communist Prague, Czechoslovakia. My parents and my sister and I escaped from there when I was 14. English is my fourth language, which I learned when starting 9th grade in California. Subsequently, my speech may be interpreted as rambling and non-responsive, and for this I apologize, and I hope that reading my oral arguments will be helpful. Briefly, the reason for my probation is as follows. In 2015, I accepted a charge of misdemeanor for aiding and abetting the practice of medicine. This was specifically related to an esthetician's use of a lancet, the tiny needle to open acne lesions before removing the acne material. During 2005 to 2009, the esthetician was leasing space in the office and specialized in treating acne. The esthetician was well known. He worked with many physicians in several clinics in the North and South Orange County area and developed his own acne skincare line. As the overly seeing physician, I would review esthetician's treatment plan and, if indicated, prescribe antibiotics for the more advanced cases or make referrals to a dermatologist for complex cases. While many states allow the use of a lancet by an esthetician, the state of California does not allow this. The in-house biller billed at the level she believed to be correct. After lengthy investigation, the Attorney General's office found there was no fraud or intent to deceive patients or insurance companies, and all charges were dropped except for the aiding and abetting the practice of medicine. I accepted the misdemeanor charge of aiding and abetting the practice of medicine because I should have known that this was not permitted in California, or I should have sought legal advice. I would like now to respond to the written arguments of the non-adoption by Mr. An. Mr. An's arguments for denial is based on the fact that, quote, the burden rests on the petitioner to prove that the petitioner has rehabilitated herself. And in this case, the proof is not clear and convincing, unquote. Rehabilitation can be defined as a process that helps people regain or improve their daily lives, but in the justice system, it focuses on helping the offender understand their wrongs. I can assure you I understand the wrong, and I believe that the proof of my rehabilitation is clear and convincing and as shown by my actions, not only in completing the board requirements, which I realize is minimum, but more importantly, how I'm conducting myself in my practice, the manner that I treat my patients with displays the highest character of a California physician. The judge, the administrative judge, clearly states in his record on page 6, number 3, that, quote, under California Code, various other criteria are to be considered. These criteria include the nature of the misconduct, the amount of time that has elapsed since the act. Additionally, the judge states, courts have recognized that rehabilitation is a state of mind. An indication of rehabilitation will be presented if the petitioner can demonstrate by his sustained conduct over an extended period of time that he is once again fit to practice. On page 6, number 4, the judge states, quote, the petitioner showed that by clear and convincing evidence that her termination is not against public interest, further stating the 11 years since the act and sustained conduct during probation. At this time, my request for early termination constitutes approximately a 6-month reduction in my probationary period. I have to this point honorably and completely served 6.5 years of the 7-year period. The purpose of probation is not for punishment, but for rehabilitation. The board determined several conditions that were to be met to develop and show my rehabilitation. The requirements are known to you, and you have evidence that I have flawlessly met every condition. The judge cited the law that rehabilitation is a state of mind, evidenced by acts over time. My state of mind, I assure you, and acts over time give proof of rehabilitation and prevention of any future acts. I would like the board to know that I have not and will not have any other mid-level practitioner or extender in my office. I care solely and directly with my patients and always will. All billing is done by a large national billing company with expertise in family medicine billing. There will never be a repeat of this situation. Lastly, I would like to address the notion that I did nothing more but the minimum. In 2008, after raising 3 girls, we adopted a newborn boy who was being safely abandoned, and a year later, his biological brother. They're now both teenagers in high school. During the height of COVID years, my office remained open, while many other physician offices only saw well patients. I saw all the ill patients. After office hours, I would also oversee the high school online school lessons with the boys. Post-COVID, I continue my practice, as well as having cared for my 90-year-old mother who contracted COVID and developed long hauler syndrome, which required bi-weekly visits to her home 90 minutes away until, unfortunately, she passed away last month, or 3 months. Goes by fast. The boys are active on varsity football, club soccer, on daily basis, games, most weekends requiring transportation to and from. Also, last year, my husband underwent a 5-vessel cardiac bypass surgery. He's now working 3 days a week. This, in addition to orchestrating the household activities, which a lot of you know, shopping, food, household essentials, boys' clothes, daily meal preparations, and the unending laundry, in addition to my medical practice, which I love. Finally, I'm in my 2nd year of law school. My intention is to focus on law as it relates to physician and especially business practices, and perhaps someday a role at the board. I wish that there was more time in my world that I could do more. However, being present and caring for my patients properly and my family fills my days. Thank you.
Thank you, Dr. Gentile. I'll now turn it over to you, Mr. On, for your opening argument. You will have 15 minutes as well, and that starts now. Thank you.
Thank you, Honor. Let us consider what placed Dr. Gentile on probation with the medical board. Dr. Gentile and 3 other doctors, including her husband, were practicing medicine with an esthetician who performed various beauty treatments, such as acne treatment. Dr. Gentile and the other doctors, including her husband, submitted numerous bills to various insurance companies under their names as doctors, representing that they performed the procedures, knowing full well that the bills are not reimbursable if submitted by the esthetician. This happened over a 5-year period. Not one remote transaction or 2 or 3, but over and over again over 5 years. The district attorney's office in Orange County, not the attorney general's office, Dr. Gentile misspoke. It was the Orange County district attorney's office who then filed a criminal complaint, initially alleging 7 felony counts, including insurance fraud and conspiracy to aid and abet unlicensed practice of medicine by the esthetician, as well as a special allegation of aggravated white-collar crime in that the damages were more than $100,000, but less than $500,000. As part of a plea bargain, Dr. Gentile pled guilty to 1 count of misdemeanor, aiding and abetting unlicensed practice of medicine by the esthetician, and was sentenced by the criminal court to 3 years probation and restitution in the amount over $166,000 and other terms and conditions. Based on that, the medical board filed an accusation, and the executive director of the medical board and Dr. Gentile, as part of a stipulated settlement, agreed that a 7-year probation by the medical board was required to ensure public protection. The medical board adopted, and her probation began in July of 2017. After 4 years and 3 months, Dr. Gentile then files a petition for early termination of probation, citing 2 reasons. 1, that she's in full compliance thus far, and 2, that it is a financial burden on her to, for example, pay for probation monitoring. There are costs that she has to bear. Now, the fact that she's in compliance with probation, that is the very minimum of what every licensee on probation must do. If Dr. Gentile was in violation of probation, the stay on the revocation of a medical license may be lifted and the license can be revoked. The fact that she has to pay for probation monitoring, the fact that probation is a burden on her to comply, that is true in every case. Now, if that were a winning argument for the panel and the board to adopt, yes, she has to pay probation monitoring, and yes, that's inconvenient. That is a burden, and therefore early termination is justified. That is not how this works and how this should work. In order to justify the extraordinary step of an early termination of probation, Dr. Gentile has to show, it is her burden, to show clearly and convincingly why that must occur. Simply, she has not met that burden. At the hearing on the petition for early termination of probation, I specifically asked her, what, if anything, have you done beyond what the medical board's probation required of you to justify an early termination of your probation? She essentially gave a very long, not cohesive answer about adopting some kids, going to law school, etc., etc. More importantly, if you look at the transcript of that hearing, starting on page 17, the quote lesson that she has learned from all of this is that she has to trust but verify. And I asked her, what do you mean by that? And she says the lesson she learned is that she has to be careful to avoid being deceived, being tricked by others. Now let's think about that. The case is that Dr. Gentile, as a doctor, submitted bills to insurance companies over and over again under her name with very specific representations that were not true. And she was working with her husband, who was also a doctor, and 2 other doctors. So we have 4 licensed doctors in California working with an esthetician. And Dr. Gentile's claim is that all 4 of them were deceived or tricked by this esthetician who performs acne treatments. And I don't mean disrespect to any estheticians, but this is a medical doctor submitting medical bills to insurance companies under their medical license. The lesson that she should have learned is to avoid, to refrain from billing incorrectly or fraudulently. And I submit to you, the members of the panel and Your Honor, and especially members of the panel who are doctors, that a doctor does not need to go to law school to refrain from billing incorrectly or fraudulently. I don't see how going to law school is a fact that she repeats at the hearing, at the petition, and again today, that's supposed to help her. The problem wasn't that she didn't go to law school. The problem was that she was not billing correctly and honestly. As a result, her journey, Dr. Gentile's journey of rehabilitation has not even begun, because she has not even taken the first step of admitting what she has done and what she has learned from it. She's denying it and at best minimizing it. Rehabilitation is not lip service, and you can't accomplish with words. She has not been rehabilitated, and therefore her petition should be denied. Thank you.
Thank you, Mr. Ahn. All right, Dr. Gentile, you have an opportunity to make a reply argument, and you will have 5 minutes to do that, and that time starts now.
Is this the same as closing, or?
Yes, I'm sorry. It's really the same reply or closing argument, either way.
Oh, okay. All right. Thank you. So I understand that the role of the board is to ensure the safe practice of medicine. I respect that greatly because it does protect all patients. I was truly shocked when learning that the lancing of acne lesions by licensed physicians was not allowed in California. And I should have known, and I should have investigated rather than assumed. I immediately and continue to admit and regret this mistake. It was an ignorance of the California rules. As Mr. Ahn states in his written argument, reinstatement requires a sufficient showing of rehabilitation to overcome the board's former adverse determination. In my records, you will find that my medical board inspector, my physician chart reviewer, my 2 physician character witnesses, and the administrative law judge, Abraham Levi, have all stated that I have provided to them a sufficient showing of rehabilitation. While the entire ordeal has been a financial hardship for me, as one would expect, but it has primarily been a hardship for many of my patients. Due to the loss of insurance contracts, many of my patients of years have been unable to continue our physician-patient relationship, and this has been a constant sorrow for me. I have been on probation for over 6 years. I would like to begin practicing with an unrestricted license prior to the end of my probation and show to the board that I am worthy of an unrestricted license and that I am a credit to the profession and the medical community. Lastly, there is a factual oversight on page 2 of Mr. An's written statement of fact. Mr. An neglected to state that the original decision of the board on September 5th, 2023 was adoption of the administrative law judge's order for granting of early termination. The order was written, signed by the chair of the panel, and sent to me. On the following day, September 6, 2023, the order was rewritten as non-adoption. A new letter was signed and sent to me, as well as a letter saying the original letter was adopted by inadvertence and mistake. I believe this shows that we are all capable of making mistakes, some much bigger than others. Thank you for your consideration.
Thank you, Dr. Gentile. And you also have the opportunity for reply or closing argument, Mr. On, 5 minutes, and that starts now.
Thank you, Your Honor. Your Honor, and members of the panel, we just heard that from Dr. Gentile that everyone, quote, makes mistakes. Now, the mistake, quote, that Dr. Gentile is referring to is not a mistake. It went on for 5 years and involved incorrect and or fraudulent billing to various insurance companies. That is not a mistake. And again, it shows that her journey in a rehabilitation has not even begun. It doesn't matter that she spent 6.5 years and is complying with every other term. If her state of mind is that this was a mistake, that the lessons she should have learned is to avoid being deceived by others and to go to law school to prevent that, we submit that no rehabilitation has taken place at all. And therefore, the minimum should be for Dr. Gentile to complete her probation, not terminated early. Thank you.
Thank you, Mr. On. All right, Dr. Gentile, I also, as I mentioned earlier on, you have the opportunity, if you wish, to make a statement under oath to the board. Would you like that opportunity?
No, thank you.
All right. Are you willing, nonetheless, to answer some questions from the board members if they have any about your petition?
Yes.
All right, then let me swear you in just so that your answers can be under oath. So if you could raise your right hand. Do you solemnly state under penalty of perjury that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. All right, so I'm going to turn it over to the board members, see if they have any questions for you. Ms. Lubiano, do you have any questions for Dr. Gentile?
No questions.
All right, thank you. What about you, Dr. Hawkins?
Yes, one question. Dr. Gentile, of the $166,000 in restitution you're required to pay, how much have you paid thus far?
It has been all completed.
No other questions.
Thank you.
Thank you. Dr. Bolat, do you have any
No
questions?
questions, Your Honor.
Oh, thank you so much. Okay, and then Dr. Tsai?
No questions, sir.
All right, and what about you, Mr. Watkins?
Just one question. Did you benefit financially from the illegal activities that was taking place within your practice?
You mean prior to the restitution? Is that what you mean?
Yes, in the 5-year period that the DAG refers to, did you benefit financially from the illegal activities that was taking place in the practice?
Yes, we were reimbursed, not knowing that could not be billed as such because there was no intent, there was no understanding of that.
Did you have a follow-up question? Mr. Watkins, I just want to make sure you got your question answered.
Yes, thank you.
All right, thank you so much. Any other board members with another question? It doesn't look like it. Okay, thank you so much. That concludes the arguments in this matter. The record is closed. Case is submitted for decision, and we are off the record in this matter. And then I'll turn it over to you, Ms. Lubiano, in terms of, I think if the closed session is next, but I'll leave it to you. Thank you.
Yes.
Thank you, Hunter.
Thank you, everyone.
Thank you.
Moving now to item number 9, closed session.